egysége, de végére nem van falikálozva a másik oldala, ott tud használni különböző hol, there are special instruments that continuously take back and forth from English to Hungarian, from Hungarian to exactly that way it works.
Esetleg szüksége lesz arra?
Nem, viszont semmit. Ide ülök mellé, jó?
Igen.
Vagy ide? Ez ilyen.
Ahogy. Mert azt néztem, hogy egyel több szék van, hogy elég sok szék van.
Nem kell. Milyen szó ezek mindenképpen ezek?
Egy nap egy 8 percet.
Hát én is arra voltam.
Még ez a régebbi program itt 15 percet írtam. De már nem értem, még az írt. Még.
Ülj ide szélére, meg hozd ide a programot, légy programot.
I sent it to you as a Google Drive link.
Yes, the works I downloaded it. Okay, thank you.
Nem, szerintem, hogy fordítsuk meg, te mondjam, de te mondtál az elején, hogy te kezd azzal, hogy te ezt megnyitottad, és mondasz még 3 megnyitottásra. De lehet, hogy aztán, hogy nem volt egy ja, fogsz előadni, ja, nem látom a kocsit. Ja, jó. Egyébként én is azt mondtam, hogy lassan az a politikus lesz, hogy nem volna beszélni. Komolyan mondom, egész itt kezdtem hétfőre egy angol vagy amerikai csapattal. Azóta volt a tegnap délelőtt egyszer magyar képviselők voltak. Most itt vagyunk, és innen megmegyek minden faluba, és utána indulok vissza haza. Komolyan, és most már mondom, most 3 napot csak oda a férjemnek, hogy ne számítsanak, ahol beszélgetünk. Ezt nem mondom, mennyire jól szeretettek?
Igen, hál' is elkezdett. Ugye 6 megy leggyorsabban, aki nagyon jól tud beütni Magyarország.
Igen. Akik egy üglőt vitelez.
Elkértük kell élni, meg segíteni. Segítő kérdés föltenni. És amikor ez volt, között iskolában francia visszatottam, hogy mondjam, mondom, hogy az édes magyar könyvszor. És sorolom visszatottam, hogy már programot
Ladies and gentlemen, I kindly ask you to proceed to your seats. Hölgyeim és uraim, kérem, foglalják el a helyeiket. I would like to ask Dr. Katalin Szili, former Speaker of the Hungarian Parliament, also former Minister for Environment, and also the Chairman and Founder of the National Sustainable Development Council, the parliamentary advisory body in sustainable development matters for the Parliament, to which organization she is still honorary president. Dr. Szili, President Szili, I kindly ask you to take the floor and have your inauguration speech.
Thank you very much. Good morning, ladies and gentlemen. I will speak my own language. I apologize, but ez itt a mi demokrácia szentélyünk, engedjék meg, hogy maradjak a saját anyanyelvemnél, és magyar nyelven beszéljek. Szeretném előjáróban is köszönteni önöket úgy, mint az egyik szervező, Nemzeti Fenntartható Fejlődés Tanács alapító tiszteletbeli elnöke, és külön szeretném megköszönni Szabó Marcell professzor úrnak a meghívást erre a kiváló alkalomra, és külön megtiszteltetés, hogy itt a vadászteremben beszélhetek, ami tényleg jól reprezentálja a magyarság, Magyarország sorsát. Tisztelt Hölgyeim és Uraim, amikor azon gondolkodtam, hogy mi legyen ennek a mai találkozónknak a mottója, általában szoktam egy mottóval kezdeni, akkor találtam egy Gandhi idézetet, ami úgy szól, hogy világon minden van, hogy az ember kielégíthesse szükségleteit, de annyi nincs, hogy kielégítse kapzsiságát. Hát egy elég sajátos világban élünk, a 21. század első negyedszázadának a végén, és sajnos, ha visszatekintünk az elmúlt jó 50 évre, mi történt a világunkból, és a világunkban, nekem is vissza kell nyúlnom néhány évtizedet, hiszen 1970 volt az az esztendő, amikor még egyetlen bolygót használtunk. 1970-ben és 70 óta folyamatosan több erőforrást használunk fel, mint amennyi a rendelkezésünkre áll, tehát már a jövőt éljük fel minden esztendőben. 1972-ben volt a stockholmi első világkonferencia, ami ugye fölismerte azt, hogy muszáj globálisan valamit lépnünk, és itt csak szeretnék önöknek egy apró történetet elmesélni. 1972-ben ugye Magyarországon a szocializmus időszakát éltük, és egy akadémiai munkacsoport készült arra, hogy részt vegyen a stockholmi világkonferencián. Slánk professzor úr, aki egyébként a segítő is volt még annak idején, és sajnos már nincs köztünk, hogy a Nemzeti Fenntartható Fejlődés Tanácsot létrehozzuk, említette, hogy a csoport összeállt, viszont a párt vezetés úgy döntött, hogy Magyarország nem vesz részt ezen a konferencián, mert Magyarországon nincsenek környezeti problémák. Hát ez egyfajta magatartás. Azóta eltelt több mint 50 esztendő, és mára már eljutottunk oda, hogy nem elegendő csak és kizárólag a környezetünkkel foglalkozni, hanem kellett egy paradigmaváltás, belátnunk azt, hogy rendszerszerűek a problémáink, tehát ezekre rendszerszerű válaszokat kell adnunk. Nem elegendő csak és kizárólag a gazdasággal foglalkozni, vagy csak és kizárólag a társadalmi kérdésekkel, vagy azzal a korlátos környezeti, természeti adottsággal, ami a rendelkezésünkre áll, hanem rendszerszerű kérdésekre, kihívásokra rendszerszerű választ kell adnunk. Így jó néhány év elteltével és akkor szeretnék önöknek két dologról szólni. Egyrészt az intézményrendszerről, amit ennek érdekében létrehoztunk, másrészt pedig azokról a stratégiai törekvésekről, amik bevezetésre kerültek, de mivel elnök úr ugye említette, hogy alapvetően a klímakérdések ennek a konferenciának a fő kérdései, nyilván a klímaügyet sem fogjuk tudni teljes egészében elvonatkoztatni a természeti ügyektől, vagy azoktól a kérdésektől, amik részben az okozati összefüggések tekintetében megjelennek. Éppen ezért felismerve azt, hogy rendszerszerű válaszokat kell adnunk, 2008-ban létrehoztuk a Nemzeti Fenntartható Fejlődés Tanácsot, amiről azt kell tudni, hogy ez egy olyan tanács, ugye Magyarországon egykamarás parlament van, amire az egyik képviselőtársam azt mondta, hogy tulajdonképpen a második kamarája a magyar parlamenti rendszernek. Jogász kollégáim majd ezt bizonyára opponálni fogják, de azért is, mert a Nemzeti Fenntartható Fejlődés Tanács 32 főből áll, és ebben a 32 főben ott vannak a parlamenti pártok képviselői, de ami a lényeges, hogy szerepelnek a civil szervezetek, és itt is köszöntöm Farkas István kollégámat is, aki ugye a Természetvédelmi Szövetség elnökeként már tulajdonképpen a kezdetektől részt vesz ebben a munkában, tehát civil szervezetek, köztestületek képviselői, egyházak képviselői, az érdekképviseletek, tehát szakszervezetek képviselői, és pontosan egy olyan döntési rendszert alakítottunk ki, ami az egyhangúságra törekszik, tehát egy konszenzusos rendszerben hozzuk meg a döntéseinket, elsősorban stratégiai kérdésekben, és ennek köszönhető az is, hogy például már 2008-ban a világon az elsők között a magyar parlament elé került az akkori klímatörvény. Nekem most nem tisztem az, hogy a klímatörvényről részleteiben beszéljek, de ez egy fontos pont volt, és hozzáteszem, a parlamenti pártok konszenzussal terjesztették a parlament elé, ami arról szólt, hogy hogyan alakítsuk ki az eszközrendszerét a klímavédelemnek. Nyilván ebben az erdősítés is benne volt, hiszen egy olyan időszakot örököltünk a rendszerváltozást 1990-et követően, amikor mindösszesen 16%-os volt Magyarország erdősültsége, ma már 25% fölött vagyunk, és a nyelőknek a rendszerének a megteremtése az szerintem egy rendkívül fontos kérdés a klímavédelemben, de említhetném itt, hogy 2010-ben készült el az az első jelentésünk, amely Magyarország fenntarthatósági állapotáról elkészült, és ezt követően, és ez volt az alapja annak, hogy 2013-ban a parlament elfogadott egy olyan határozatot, aminek a melléklete Magyarország fenntartható fejlődés stratégiája, 12 évre szólt, 2013-tól 24-ig, és 2 évente köteles volt a Fenntartható Fejlődés Tanács jelentést adni Magyarország fenntarthatósági állapotáról. Ez folyamatos tükröt tartott a közvélemény és a politika előtt is, hogy hol tartunk ezekben a kérdésekben, hiszen ez egy olyan alapdokumentum, amihez igazodnia kellett valamennyi egyéb stratégiának, ha már a rendszerszerűségről szóltam, és nyilván fontos kérdés volt az is, hogy ugyanezen időszakkal egybeesett az új alaptörvényünk, tehát alkotmányunk megfogalmazása, amiben például, és akkor itt csak a 5 helyen is szerepel mindazon kérdés, ami a természeti értékeink megóvásától kezdve az erőforrásainkig szerepel. 5 helyütt, ebből egyetlen egyet emelnék ki, ami a hitvallásról szól. Felelősséget viselünk utódainkért, ezért anyagi, szellemi és természeti erőforrásaink gondos használatával védelmezzük az utánunk következő generációt. De hozzáteszem, megfogalmazza benne az állam kötelezettségeit is, és még egy dolgot kiemelnék, ami úgy szól, hogy Magyarország az emberiség fenntartható fejlődése érdekében, tehát még a szó is szerepel az alaptörvényünkben, együttműködésre törekszik a világ valamennyi népével és országaival. Most itt akár be is fejezhetném a beszédemet, és azt mondhatnám, így hát ezért köszöntöm Önöket itt a Magyar Parlament épületében és a vadászteremben, mert hogy pontosan jelzi azt a mostani találkozónk is, hogy ez az együttműködés, ez tényleg egy kézzel fogható valóság. De itt azért nem fejezném még be, és még egy picit kérem a figyelmüket, hiszen alkotmányunk, ahogy említettem, páratlan részletességgel szabályozza a fenntartható fejlődés, illetőleg a természeti értékeink megóvásának a kérdéseit, és hozzáteszem azt is, hogy azzal az első stratégiával, ami 12 évre szólt, és ami lezárult az elmúlt esztendővel, ennek a stratégiának az is volt a címe, hogy a fenntarthatóság felé való átmenet. Tehát volt ez a 12 éves időszak, ami ezt az átmenetet jelentette, de itt nem fejeztük be, hiszen már készen van tervezetben a következő 12 év stratégiája, ami 2025-től szól 2036-ig, tehát egy következő 12 éves időszakot ölel fel, és amiben nyilvánvaló, hogy számunkra azokat a kérdéseket jelöltük meg, és itt szeretnék egy dolgot kiemelni. Az előző stratégiánk, ami az átmenetet jelentette, az egy elég sajátságos módszert alkalmazott, és ebben külön szeretném Bartos Gábor Fenntartható Fejlődés Tanács főtitkár urának megköszönni azt hiszen elévülhetetlen érdemei vannak, mint szakembernek, hogy egy olyan rendszer alakult ki, amiben nem csak és kizárólag a védendő értékekről szólunk, és az indikátorokról, meghatározza azt a felelősségi rendszert is, hogy ebben a stratégiában, milyen végrehajtásában és a célok elérésében milyen szerepe van kormánynak, önkormányzatoknak, vállalkozóknak, gazdálkodó szervezeteknek, civileknek, és hozzáteszem a családoknak is. Tehát megalkotta azt a mátrixot, amiben a védendő értékeket és a felelősségi rendszert harmonizálta, de hozzáteszem, mivel az SDG-k, a fenntartható fejlődési célok, ami ugye 2015-ben került elfogadásra, akkor még nem szerepeltek, a most elkészült és majdan a parlament elé szintén jóváhagyásra kerülő stratégiánk már harmadik dimenzióként behozza az SDG-ket is, és azt is megfelelteti ennek a rendszernek, ami tényleg meghatározza azokat, és akkor csak 3-at emelnék ki a cselekvés kulcságazataiból, a területhasználat reformját, a körforgásos gazdaságot és a karbonszegény gazdaságot, és azért is említem, mert ennek a második stratégiának a címe már a fordulatot jelenti, tehát szeretnénk egy jelentős fordulatot elérni a működésünkben, és én azt gondolom, hogy ez nagyon jól láttatja, nem csak és kizárólag a politikusokkal, nem csak mint egy lelkiismeret vagy tükör tartható elénk, hanem én azt gondolom, hogy az egész társadalom számára világossá teszi azokat az irányokat, amit képviselnünk kell, akár koncepciók, stratégia vagy jogalkotásban. És végül egy dolgot szeretnék kiemelni. Ha már én sem tudom megtagadni nyilván politikusi mi voltamat, hogy 2013-ban, amikor megalkottuk és a parlament elfogadta az első stratégiánkat, akkor ahhoz a parlament elfogadott egy országgyűlési határozatot. Ez az országgyűlési határozat fölvállalt egy olyan dolgot, ami azt gondolom, hogy kevés parlamentben történik, mégpedig azt, valamennyi jogszabályunkat, ami a parlamentben készül, Ami előterjesztésre kerül, a Fenntartható Fejlődés Bizottsága, mert van egy ilyen bizottsága is a parlamentnek, megszűri az alapján, hogy mennyire felel meg a fenntarthatóság kérdéseinek. Én azt gondolom, hogy ez az az intézményrendszer, ami tulajdonképpen a mi rendszerszerű gondolkodásunk szabályozási kereteit adja, és én remélem, hogy ezzel ugyanúgy úttörők vagyunk, mint ahogy voltunk akkor, amikor a tanácsot, mint egy konszenzus köteles vagy konszenzuális testületet létrehoztuk. Én köszönöm a figyelmüket, köszönöm, hogy ezt elmondhattam, és kívánok önöknek szép napot, további jó tanácskozást, és minden kiváló praxist szívesen fogadunk. Elnök urak, köszönöm a figyelmeteket, és érezzék jól magukat Budapesten. Köszönöm szépen.
Our first speaker today will be President András Vargasi, who is the president of the Curia of Hungary and also serves as a professor and chair at the Pázmány Péter Catholic University. Vargasi András served as a deputy prosecutor general between 2000 and 2006 and between 2010 and 2013, and as a justice of the Constitutional Court between 2014 and 2020. He has been a Hungarian member of the Venice Commission since 2013 and the Vice President of the Constitutional Court Subcommittee since 2019. Vargasi András is head of the Department of Public Administration at Pázmány Péter Catholic University, and he was Dean of the Faculty of Law between 2013 and 16. His main area of research is related to the examination of the constitutional foundations of administrative law. The title of his lecture today is "What Can Ordinary Courts Do to Protect Nature and Our Climate?" Please, President, take the floor.
Your Excellency, Madam Speaker, Excellencies, Honorable and Right Honorable and Honorable Justices and Judges, distinguished colleagues, professors, ladies and gentlemen. In protection of the nature, landscape, and in particular the climate, is not only an environmental or scientific issue, but also a complex subject that raises significant social, economic, and what is more important for us, legal questions that may affect everyone. Please allow me to express my thoughts, especially on climate protection from this point, because in recent decades, there has been a significant increase in the number and importance of legislation codifying responses to climate change. As a starting point, I would like to point out that even though the provisions of the fundamental law, or in better translation, the Basic Act of Hungary, do not contain a specific definition of nature, landscape, or climate, they do clearly refer to the environment and mention certain natural resources, such as arable land, forests, and water resources, as examples which the fundamental law considers to be common heritage of the nation. What is more, I would like to strongly emphasize that the fundamental law has a complex approach to environmental protection, which is clearly reflected by the following factors. Firstly, the right to a healthy environment is guaranteed at constitutional level. Secondly, the relationship between environment and other human rights, the right to health, for example, is also expressed in details in the fundamental law and in the interpretation of the Constitutional Court, for instance, regarding the connection with the healthy environment to health, the right of life. Furthermore, it is important to point out that the fundamental law also links proper waste management to the right of healthy environment. In safeguard, the prevention of GMO-free status of Hungarian agriculture, and it also mentions the polluter pays principle, which is, I think, one of the very, very few examples where this question is mentioned in a constitution of a state. And it's also created the post of Deputy Commissioner for Protection of Interests of Future Generations, Professor Bundy, who deputizes for the Commissioner for Fundamental Rights, and the Deputy Commissioner's activities are primarily related to the protection of the environment and cultural heritage. Sharing the prevailing professional opinion on to the subject, I myself also believe that Hungary's fundamental law is based on a solid doctrine that represents the importance of environmental protection. This is manifested in the high level of legal protection guaranteed by the mentioned constitutional provisions. Ladies and gentlemen, in recent years, the courts had become an increasingly important arena for the protection of the environment, landscapes, and the climate. Over the past 30 years, climate protection litigation, which is an umbrella term, has been documented in many countries, and these types of legal disputes are taken to the Court of Justice of the European Union and the European Court of Human Rights in growing numbers. Hungary is no exception of this trend either. Those legal disputes which can be included in this category are extremely diverse and can affect the following. Firstly, the area of constitutional law in cases where the dispute is based on the state's obligation, the state's constitutional obligation to its citizens. Secondly, the area of private law, as long as the plaintiff's claim is based on negligence, trespass, or the right of compensation. And of course, the legal disputes may be associated with environmental crimes, which may also be of transnational nature, and other questions can be connected to human rights claims. For example, the plaintiffs may invoke international human rights instruments, and finally, they may be realized in the framework of administrative law claims with the aim of reviewing administrative decisions or judicial review of administrative decisions and other official acts. Given the time constraints of my presentation, I will now explicitly mention only the constitutional and administrative law aspects. With regard to the constitutional aspect, I would like to indicate that the Constitutional Court of Hungary has, on several occasions, underlined the importance of precautionary principle and its connection with the achieved level to protection of the environment and nature, and with the prohibition of reducing the level of protection. Just in parentheses, even if I had dissenting opinion in these decisions. In one decision of the Constitutional Court of 2018, the Constitutional Court stressed the following. Whenever legislation on environmental protection is amended, the legislator must also consider the precautionary principle and the principle of prevention because, I quote, failure to protect the nature and the environment may trigger irreversible processes. In another decision of 2017, the court stated that the state must ensure that a given measure does not lead to deterioration of the condition of the environment. In the context of administrative litigation at the ordinary courts in Hungary, It is worth briefly mentioning the following judgments in line with the decisions of the Constitutional Court. I will not quote the number of the cases because it's not very important, only the core of the decisions. In a case in 2024, last year, the Curia stated that with regard to the protection of natural and cultural resources that form the common heritage of the nation, Article P of the fundamental law stipulates the state and everyone's expected obligation. Consequently, not only the legislator, but also everyone else, including those who apply the law, should be careful to maintain the level of protection that has already been achieved. In another decision of last year, Hungary's Supreme Judicial Forum elucidated the possibility of the Commissioner for Fundamental Rights to join any administrative lawsuit which affects the protection of environment. In the third case, it's a bit older, the Curia had adopted a position in a lawsuit for challenging an action plan aimed at improving air quality. When describing some relatively important procedural and substantive findings of the case, I would like to underscore some of them. First, the right to participate in environmentals, and in this context, the right to access justice are not unconditional, nor are they unlimited. And they cannot be independent of the applicable laws. Secondly, not all proceedings or acts of the administrative bodies establishing rights or obligations give rights to administrative case that falls within the scope of the acting case on administrative procedure. An information letter does not have any legal effect. Why is this important? Because in some situations it's not very clear whether a natural act of an administrative body can be understood as a legal act as an administrative body, or it's only a kind of conversation with the interested parties. And the case in problem was whether a simple, an informal answer from an administrative body can be challenged at the court or not. And this led to the third part of the answer, that the ex lege right, so coming from the law, to bring an action gives environmental associations a legal possibility to act in order to protect environment, a task that they have undertaken voluntarily, but in the court case, the plaintiff mixed the various entitlements granted to environmental associations with other entitlements that are regulated under the Environmental Protection Act. Ladies and gentlemen, I think that this last example was a bit complicated. Consequently, I tried to explain it. There is no doubt that in the fight against climate change, courts have an important role to play. A fundamental question is whether the courts pay sufficient attention to issues relating to the protection of nature. And I believe that there is only one answer, one right answer to this question. Courts have to take into account everything they can. But, and this but is crucial, courts take into account everything they can but only within the framework of the court proceedings. In other words, they should pay attention to everything, but only regarding the applications and answers the position of the litigants. An active judicial attitude, a very, very limited active judicial attitude, can be regarded as a general rule which undoubtedly contributes to raising awareness and may galvanize decision-makers into action. But again a but. A judge may not decide on arguments which are not pointed out by the litigants, by the parties. In addition to legal actions for challenging an administrative decision and certain personality right disputes, I should especially highlight the procedural institution in Hungarian administrative procedural law that provides for the possibility of action before administrative courts. If you translate word by word, it's called the omission lawsuit. In this lawsuit or this application, the applicant can argue not only on the illegality of an administrative action, but also on the lack of an appropriate administrative action. In other words, ignorance of administrative bodies to fulfill the legal or constitutional duties may lead to a lawsuit, to a trial in an administrative court. In a recent civil dispute, the Curia, the Supreme Court of Hungary, has also oriented the rights of organizations towards this omission lawsuit, and I think this omission lawsuit is what makes or gives floor to the courts to be active in protection of our nature, of our world. Thank you very much for your attention.
Ladies and gentlemen, yesterday many of you were present already at the conference, but there were others who just came today, a special greeting to them as well, in order so that they would also know Justice Attila Horváth, the acting president of the Constitutional Court. I will just say 2 or 3 words about him. Attila Horváth is a professor of law at the Department of Legal History of the Ludovika University of Public Service in Budapest. He teaches also at the Péter Pázmány Catholic University at ELTE Law School. His main research area is the Hungarian constitutional history and human rights violations under Soviet-style dictatorships. You may at the first sight think that climate and law history don't have too much in common, but in the recent judgment of the Hungarian Constitutional Court, we realized at the court, thanks to President Attila Horváth, that they are going hand in hand. Please, Chief Justice Horváth, please take the floor and have your lecture.
Köszönöm szépen. Ismételten tisztelettel köszöntöm a konferencia előadóit és hallgatóságát, hiszen már tegnap már találkoztunk, és engedjék meg nekem, hogy a magyar történeti alkotmányról magyarul tartsak önöknek előadást. Ahogy Szili Katalin házelnök asszony említette, hogy a szocializmus időszakában a környezetvédelem nem élvezett prioritást, ugyanúgy a történeti alkotmányról is próbáltak megfeledkezni, ahogy akkoriban énekelték, a múltat végképp eltörölni, pedig ez egy olyan nagy értéke Magyarországnak, a magyar jogi kultúrának, amit mindenképpen meg kellene őrizni, mindenképpen ápolni kell. Már csak azért is, mert a környezetvédelem is nagyon fontos szerepet töltött be mindig is a magyar történeti alkotmány fejlődése során. De a rend kedvéért azért néhány gondolatot hadd mondjak el bevezetésképpen, hogy tulajdonképpen hogyan is értelmezzük mi a történeti alkotmányt, és hogyan értelmezzük azt, hogy ennek milyen részei, milyen területei azok, amik ma is a hatályos alkotmányunknak a részét képezik, és ez milyen módon történik. A történeti alkotmány tulajdonképpen úgy határozható meg a legegyszerűbben, hogy a sarkalatos törvények, tehát ezek a legfontosabb törvények, amik 1000 éves alkotmányunk során születtek, a szokásjogi szabályok, itt különösen gondolok a legfelsőbb bíróságra, a kúriának a szokásjogára, de egyéb szokásjogi szabályokra is, amiket különböző helyen összegyűjtöttek és megőriztek, illetve amiről leginkább meg szoktak feledkezni, a jogtudomány álláspontja. Tehát az is a történeti alkotmány része, az a felhalmozott tudás, amit több száz év alatt a magyar jogtudósok alkottak, és amik bizony ma is nagyon nagy segítséget nyújtanak, amikor gondolkodunk valamilyen kérdésről. Mindennek alapján az alaptörvény már a Nemzeti Hitvallás című részében szól a történeti alkotmányról, idézem: tiszteletben tartjuk történeti alkotmányunk vívmányait és a Szent Koronát, amely megtestesíti Magyarország alkotmányos állami folytonosságát és a nemzet egységét. Az alaptörvény cikk 3. bekezdése pedig kimondja, az alaptörvény rendelkezéseit azok céljával, a benne foglalt nemzeti hitvallással és történeti alkotmányunk vívmányaival összhangban kell értelmezni. Ez a vívmány kérdés, ez a vívmány szó némi magyarázatra szorul, hiszen ez a magyar jogi szakirodalomban korábban nem volt alkalmazásban. Ezt inkább az európai jogból vettük át, de mégis fontos, hogy ez így magyarázatul szolgáljon az egyes kérdéseknek a megvilágításánál, meg elemzésénél, ugyanis nem szabad a történeti alkotmányt egy ilyen kívánságműsorként fölfogni, és amelyik jogszabály nekünk szimpatikus valami miatt azt teljesen tetszőlegesen kiragadni, hanem azok a részei alkalmazhatók a történeti alkotmánynak, amelyek hatályosulak, amelyek a mához szólnak, és ezeket egyszerűség kedvéért mondjuk azt, hogy vívmányok, és így ezekre is hivatkozunk. És ezért mondja ki az Alkotmánybíróság is a 33/2012-es határozatában elvi jelleggel, hogy az alaptörvény cikk 3. bekezdése nem önmagában a történeti alkotmányt, hanem annak vívmányainak jelentőségét hangsúlyozza. Az Alkotmánybíróság tehát ezért hangsúlyosan rögzítette egy másik határozatában is, az a 22/2019-es, amelynek indokolásában azt írja, idézem, történeti alkotmányunk tehát nem minden eleme vívmány. A történeti alkotmány elsősorban a jogértelmezésnél ad támpontokat, tehát azt kell ugye tudnunk, azt kell figyelembe vennünk, hogy amikor valamilyen környezetjogi kérdést tárgyalunk, és ez több ilyen is volt, legutóbb például a Szabó Marcell tervezeténél merült ez föl, Szabó Marcell professzor úr, alkotmánybíró társamnak a tervezeténél merült föl, hogy bizony az indokolásnál tudjuk erősíteni azokat a megállapításokat, amelyeket itt teszünk. Nézzünk néhány olyan jogintézményt, amik történeti alkotmány vívmányaként szerepelnek, és amelyekre az Alkotmánybíróság hivatkozott a fenntartható fejlődés, a környezetvédelem, a klímavédelem szempontjából. Nézzük meg ezeket sorra. Tehát például az Alkotmánybíróság 14/2020-as határozatának indokolásában kimondta, az alaptörvény P. cikk első bekezdésének az erdők jövő nemzedékek részére történő megőrzését előíró rendelkezése nem tekinthető történelmi előzmények nélküli előírásnak. A jogalkotó már az alaptörvény hatályba lépését megelőzően évszázadokkal felismerte az erdők jelentőségét. Az erdőkre vonatkozó jogi szabályozás főbb elemeire már 100 évvel ezelőtt is úgy fogalmazta meg a szakirodalom, idézem, senkinek sem állhat jogában erdejét a jövő nemzedékek rovására túlhasználni, vagy éppen pusztítani. Továbbá, megint idézett egy másik helyről, az erdők fenntartásáról rendelkező legrégebbi törvényeink a tékozásról, a pazarlásból eredő minden erdőpusztítás megakadályozását, bárkiről is legyen szó, a közhatalom feladatává teszi. Azt nem kell különösebben hangsúlyoznom, a jogászok ülnek többségében ebben a teremben, hogy milyen fontos az, hogyha egy jogintézmény több száz éve jelen van egy adott ország jogéletében, és az meggyökeresedik, és a mindennapi életnek a részévé válik, és teljesen természetessé válik a jogkövető magatartás. Mint hogyha hirtelenjében ránk zúdítanának több tucat jogszabályt, és azokat kellene nekünk egyik pillanatra a másikra értelmeznünk. Például a 1581 és 1848 között folyamatosan jegyzőkönyvben foglalt székely falutörvények. Azt hiszem, amikor a paraidi bánya szerencsétlenségre gondolunk, nekem ez volt az első asszociációm, hogy a székely falu törvényeket a legmesszelenőkig betartották volna, akkor most nem lenne ez a rettenetes tragédia, ami ott történt, és ami félő, hogy visszafordíthatatlan irreversibilis változásokat hozott, és egy olyan értéket, amit 800 éve őriztünk és gyarapítottunk, egy olyat egyik pillanatra a másikra elveszítünk. Hiszen ezek a székely falu törvények magas színvonalú gazdálkodási rendszerre biztosították a közösség erdőségeinek védelmét, regenerációs képességét, felelősnek mondván magukat arra, hogy elődeiktől rájuk hagyott örökséget uraiknak, unokáiknak megőrizzék. Gondolják el, hogy a székely emberek azok lelki közösségben éltek a környezetükkel, erdejékkel. Minden egyes fát sajátjuknak éreztek, megbecsültek, és az teljesen természetes volt minden székely ember számára, hogy minden egyes kivágott fát, akár nem is egyel, hanem többel azonnal pótoljanak, és csak olyan fát vágjanak ki, amelyek úgymond vágásra érettek, vagy amelyeket egyéb okból kellett kivágni. Tehát ilyen tarvágások, értelmetlen pusztítások még gondolati szinten sem merültek föl a székelység körében. De ugyancsak idézhetem első Miksa király által kiadott erdészeti rendelkezést, az 1565-ös Constitutio Maximiliana, amely a magyar királyi bányavárosok joghatósága alatt levő erdők vonatkozásában előírta a tervszerű erdőgazdálkodást, és a hasznos gyümölcsöket termő fák megtartásának követelményét. Továbbá korlátozási időket határozott meg a vadállomány fenntartása céljából. Mária Terézia királynőnk 1769. december 22-én adott ki az egész Magyar Királyságra érvényes általános erdőrendtartást, amelyek egyebek között megadta az egyes fafajták felnövekedéséhez szükséges időt, és elrendelte, hogy a fákat csak vágás érett korban szabad kivágni. Az erdő rendtartása tölgy és cserfa esetében a vágás érett kort 200 esztendőben határozta meg. Ez a jogalkotás és jogtörténeti példája az erdők jövő nemzedékeinek érdekeire való figyelembe vett szabályozásnak. Az erdők pusztításának megakadályozásáról szóló 1790-91. évi 57. törvénycikk aként rendelkezett, idézem, bárkitől eredjen az erdők pusztítása, a vármegyék a dolog törvényszerű és hathatós megvizsgálása után a pusztító ellen indított ügyészi kereset terhe alatt a szükséghez képest zárlatot is alkalmazva akadályozzák meg a pusztítást, épségben maradván a vármegye által meghatározott mérsékelt használat és a törvény útja. A törvénycikk ennek megfelelően elrendelte a magángazdálkodókkal szembeni fellépést is, az okszerű, mérsékelt használatot meghaladó erdőgazdaság esetén. Az 1879. évi 31. törvénycikk, az első átfogó erdőtörvény számos olyan erdőterületen vezette be a tarvágás teljes tilalmát, amelyek elsődleges célja a védelmi rendeltetés volt. A törvény nem csupán az állami, de számos magántulajdonú erdőterület esetében is előírta a gazdasági rendszeres ütemterv készítését, amelyet jóváhagyásra a földművelésügyi miniszternek kellett beterjeszteni. Az 1935. évi 4. törvény, miközben bevezette az erdőgazdálkodási ütemterv készítésére és a miniszteri jóváhagyásra vonatkozó kötelezettséget, előírta, hogy az erdőtulajdonos az erdőben nem gyakorolhat, nem rendelhet el és nem tűrhet el olyan műveletet, amely az erdő védelmi rendeltetésével ellenkezik, tehát követelményé tette továbbá az okszerű erdőgazdálkodást, figyelemmel az erdő állapotára és rendeltetésére, annak érdekében, hogy az erdő fennmaradása biztosított legyen. Mindezek a korábbi jogszabályi rendelkezések alapján megállapítható, hogy a magyar jogrendszerben évszázados múltra tekint vissza az erdők megóvására vonatkozó állami kötelezettségek előírása, az erdők tulajdoni formájától függetlenül. Erre tekintettel Az Alkotmánybíróság az állami magántulajdonú, tehát az állami és magántulajdonú erdők megóvásának kötelezettségét a történeti alkotmány olyan vívmányának tekinti, amelyet az alaptörvény értelmezése során, tehát az ERCI harmadik bekezdésének megfelelően figyelembe kell venni. Az Alkotmánybíróság legújabb 2025. június 3-án elfogadott határozatában, ahogy az a megnyitó beszédben is hangsúlyozottan elhangzott, kiterjesztette a P cikk első bekezdésének védelmi körét a klímára is. Az alaptörvény P cikke a természeti erőforrások között a különösen kitételt követően a termőföldet, az erdőket és a vízkészletet, a biológiai sokféleséget, valamint a kulturális érdekeket sorolja fel. Tekintettel arra, hogy az Alkotmánybíróság határozatának, vizsgálatának tárgyát kifejezetten és kizárólag az erdők képezték, egy korábbi határozatnál utalok most vissza, a 14/2020-as, ezért az Alkotmánybíróság ebben a határozatában és a legújabb határozatában is megvizsgálta az alaptörvény P cikk első bekezdésében nevesített nemzet közös örökségének részét képező természeti erőforrásokkal összefüggésben a történeti alkotmány vívmányának tekinthető megállapításokat is, azonosíthatóak-e a következő megállapítások alapján mindezek. És hát itt most egy hosszú felsorolás lenne, amivel nem untatnám a kedves hallgatóságot, mert több tucat ilyen jogszabályt kéne felsorolnom, kezdve Szent László királytól, aki 1077-től 1095-ig uralkodott, és bezárulva egészen a 19.-20. századig különböző törvényekig. Csak azért említem ezt így, mert hogy tudatosodjon mindenkiben, aki most itt hallgatja ezt az előadást, hogy Magyarországon folyamatosan, tehát a 1077-től uralkodó Szent Lászlótól kezdve folyamatosan születnek az olyan törvények és az olyan rendelkezések, amelyek a fák védelmével, a környezetvédelmével, úgy mondanánk a klímavédelemmel is foglalkoztak. És amikor már a modern törvényalkotás kezd kibontakozni a 18.-19. században, akkor ezek már egyértelműen olyan konkrét megállapításokat tartalmaznak, amelyek akár szó szerint is alkalmazhatók lennének a mai jogszabályokban is. Sajnálatos módon, ahogy említettem az előadás elején, ezek a második világháború után kezdődő kommunista rendszerben egészen a rendszerváltozás ideig ezek háttérbe szorultak, kevésbé lehetett rájuk hivatkozni, és már majdnem feledésbe mentek, amikor az alaptörvény újra figyelmünkbe ajánlotta, hogy ezeket a történeti alkotmányvívmányokat, ezeket meg kell őriznünk, ezekre komoly figyelmet kell fordítanunk. Tehát konklúzióként rögzíthetjük, hogy bár az Alkotmánybíróság már az alaptörvény előtt komoly figyelmet fordította az elé kerülő kérdéskörre releváns jogtörténeti előzményeire, itt úgy értem az alaptörvény előtti időszakot, hogy a rendszerváltozás időszaka 1989-90-től az alaptörvény hatályba lépéséig időszakra utalok. Esetenként hivatkozta már akkor is a történeti alkotmányunk egyes rendelkezéseit. Egyúttal azonban az alaptörvény rendkívüli felelősséget hárított az Alkotmánybíróságra, amikor kimondta, a konkrét ügyek vizsgálatakor kötelezően be kell emelnie kritikai horizontjába a jogi intézmény történet releváns forrásait. Ezt a 33/2012-es alkotmánybírósági határozat állapította meg. Az Alkotmánybíróság ezt a felelősséget felvállalva azonosította a történeti alkotmánynak azon vívmányait, amelyek alátámasztják, hogy Magyarország és a Kárpát-medence természeti és éghajlati viszonyának védelme évezredes múltra tekint vissza. Reményeim szerint ez a történelmi múltra való visszatekintés, a környezetvédelemnek a maga történetiségében való magyarázata erősíteni fogja Magyarország állami szerveinek és polgárainak környezettudatosságát is. Köszönöm szépen, hogy meghallgattak. Köszönöm szépen.
Tisztelt Hölgyeim és Uraim! Azok, akik azok a kedves bírótársak, köszönjük szépen, még egyszer köszönjük. Azok a kedves bírótársak, akik szintén a magyar néphadsereg kötelékében voltak kénytelenek szolgálni egy ideig, azok ismerik azt a fordulatot, hogy magamnak vezérlek, magam hajtom végre. Tehát most magamat kell felkérnem, amit ünnepésen is fogadok, hogy megtartsam az előadásomat a klímatörvénnyel kapcsolatban, és az előadás angolul fog zajlani, aminek az oka, hogy azt gondoljuk, hogy ez egy értékes és fontos döntés, amelyet már is szeretnénk a nemzetközi közösség számára is bemutatni, és valamilyen módon összehasonlíthatóvá tenni az egyéb nagyon fontos francia, német, koreai, belga klímavédelmi döntésekkel. So, ladies and csak egyetlen kérdés, hogy hol tudom a előadásomat elkezdeni, egy technikai segítséget szeretnék kérni. A Szemesi Sándor kérném, hogy segítsen, hogy a prezentációt el tudjuk kezdeni. Hopefully it will arrive, but let me say a few words about the background of the decision. The background, well, actually, the Hungarian Climate Protection Act was adopted in 2020, and already at the beginning there were certain on the one hand, it was celebrated that Hungary was the first country in which climate neutrality was declared. That was very, very important, and that it's a very significant part of the Climate Protection Act. On the other hand, the Climate Protection Act is not longer than one page, which means that it doesn't have a very detailed obligational structure, and that was entailed to some level of criticism already at the beginning. And a very interesting thing happened that in 2020 the target was set for 2030, that the emission level should be reduced to 40% of what it has been at the year 1990. And actually, 2 years ago, the minister responsible for climate said very proudly that we can announce to the Hungarian public that we have already achieved this target, that this target is fulfilled, which meant that there was no further target to be achieved until 2030, and there was, of course, a very short time period until 2050 to reach total climate neutrality. So it was already a question whether it is acceptable that we should not go any further until 2030 and just let 7 years pass without any concrete results and any further achievement. And as it has been already mentioned, we annulled a provision from the Climate Protection Act, which is actually Section 3. We declared it unconstitutional due to the violation of intergenerational justice, the principles of precaution and prevention. These legal categories are arising from Article P of the Hungarian Basic Law. I will introduce it in more detail in a second, but the exact text of the Climate Protection Act, which was annulled, was Hungary shall reduce its greenhouse gas emission by at least 40% by 2030 compared to 1990. We cannot go further without saying just a few words about our strongest weapon at the Constitutional Court based on Article P of the Basic Law. This relates to natural resources. It says natural resources, in particular arable land, forest, and the reserves of water, biodiversity in particular, native plant and animal species, and cultural artifacts shall form the common heritage of the nation. It shall be the obligation of the state and everyone to protect and maintain them and to preserve them for future generations. I will get back, for those who are international lawyers, I will get back to this concept, the common heritage of the nation. How does it relate to common heritage of mankind and common concern of humanity also later? But this is our strongest weapon. Let's line up the different legal basis that is encompassed by Article P. First, the Constitutional Court, after looking into the provision deeply, made it very clear that Article P also dealing with climate change. It is dealing climate change because we are not going to have the same landscape, the same water resources, the same forests, the same landscape unless we do the necessary precautionary measures so that the elements of natural heritage to be given to future generations in an intact way should not be specifically safeguarded. It needs also the Hungarian state is required to deal with mitigation, adaptation, and resilience so that Article P could be fulfilled. This is a clear legal instrument of intergenerational equity. Of course, we have to pass over our natural and cultural heritage to future generations. Obviously, it's a matter of intergenerational equity that we have to preserve this element of our nature and our culture. And obviously, if we have got a very significant target, a reduction of the CO2 emission by 2050, if we do not do anything until 2030, it obviously means that future generations will have a higher burden with an accelerated speed of reduction later. The public trust doctrine is also part of this concept and the principle of non-derogation, which is actually a concept which was, I think, developed by the Hungarian Constitutional Court, and then it was penetrated into the legal science of many, many countries. It has been rethought by this decision, and let me say 2 words also about it. But first, we were very proud to realize that Article P is in line with the public trust doctrine. We know very well that, for example, in the Montana case in the United States, public trust doctrine played a very significant and important role. And I think one of the important reasons for the dialogue of the courts is that judges like to repeat each other, use references of other judgment sayings, and if we have a common language to use for climate protection, I think it's a good way to go forward, not even on international level, but also on domestic and national level. The obligation to preserve natural and cultural objects, we made a statement actually which relates to customary international law. We made it purposefully because we thought that there might be courts who would like to use a similar concept. And what we are taking a stand would be very nice if it was part of customary international law. So we declared it to be part of universal customary international law, and hopefully more and more courts, bodies will realize it is a part of customary international law, and that is one way to develop universal customary international law. So what we actually said is that the preservation of natural and cultural resources for future generations is also part of the newly established and consolidated universal customary international law. It was not something that we must of necessity need in the judgment, but it wanted to be our contribution towards the international community. We also rethought how the obligation of non-regression should be understood. In an easier way, we will say in Hungarian, we speak about visszalépés tilalma, the obligation not to step back, and we turn this obligation in a way, an obligation to step forward. It's also, we have also a very significant inspiration from the Gabčíkova Nagymaros case. There's a certain part of the judgment where the court is saying that it would be an adjudication of the law out of touch with reality if the court would, at this point, evaluate the legal norms as it were several decades ago, because it were overtaken by events. So that is the international leg of our thinking, what we are thinking, that something can be okay and perfectly all right at a given time, but climate change is happening in a very, very rapid way. And if we don't include the elements of precaution and prevention and science into the evaluation of the validity of norms, then we make a mistake. A norm can be perfectly constitutional and legal at a certain point, but at a later stage we can realize that it was overtaken by events because of the facts of climate change, because of the facts of science, because the requirement to have a regard to prevention and precautionary principle. President Attila Horváth was referring to a terrible story, what is happening in Transylvania, that a salt mine which was used for hundreds and hundreds of years now collapsed because water was actually find its way into the cave, and of course if there is water and salt together, the salt mine will not survive, unfortunately. It's a terrible, terrible story, and one used to the fact that there is a small river, sometimes there is a little more rain, but everything is manageable somehow. But it turned out that there was a point, because of the changing of the weather, and because of cutting of the forest, which should have been preserved, by the way, the things have changed, and we couldn't have preserved this treasure the way it has been preserved. And that needs a revaluation of the principle of non-regression to a principle, the requirement to step forward. So it's a dynamic obligation, not a static obligation. Simply, if the lawmaker did not change the text of the law, doesn't mean that the text is still constitutionally valid. National aspects. I'm very curious here also about the opinion of our dear Constitutional Court Judge guest, because I think beyond the international horizon, we have to really think the threshold for protection of natural and cultural heritage based on basic constitutional concept. And and it relates in a way to national identity. And we actually mentioned that the national identity is, on the one hand, includes a web of social and personal relationships. That is something, who we are. That's a nation, a web of personal and social relationships. But at the same time, there is a heritage that is actually an emotional attachment to a landscape that was the land of the Norwegians, the Bavarians, the Hungarians, the Czechs for hundreds and hundreds of years. And part of their national identity is relating to their own, to the landscape that is requiring a preservation in itself on that basis. We were specifically concentrating in this judgment on the Hungarian constitutional requirements, but of course we couldn't have disregarded of international obligations, and it's a very interesting thing that on the one hand the climate protection law said 40% as the target for 2030. At the same time, Hungary has given a declaration to the European Union itself. So it was not the Union's obligation. The Union's obligation was to do something, but Hungary has declared what it believed it can do in order to mitigate and reduce emission targets related to climate change. And Hungary's National Energy and Climate Plan, which was revised in 2023, is saying that Hungary will reduce gross greenhouse gas emission by at least 50% compared to 1990. And it's, yesterday Tamás Ádány was speaking of the international legal approach to the national energy and climate plans. And I think from an international legal perspective, it's a unilateral declaration made by a state. So it has got an international legal value. And what the court said about this plan is that in the event that the strategy sets more ambitious objectives, that's the full quotation, then the provisions of the Climate Protection Act, then the requirements deriving from the basic law, particularly the principles of precaution and prevention, demand the strict adherence to and implementation of these more rigorous objectives. So that was the way how the court was related to Hungary's self-made unilateral declaration. Also, there is another internationally promulgated strategy of Hungary, adopted by its own. That's the National Clean Development Strategy of Hungary. The National Clean Development Strategy is encompassing 3 different potential scenarios how we will reach climate neutrality by 2050. And it includes 3 different pathways. One is the business as usual scenario. You don't have to do anything. Later everything happens. Ölbetett kéz in Hungarian, the name of the version. Late action scenario and early action scenario. And also the court said in relation to the scenarios, based on the fundamental law, Hungary is obliged to aim primarily for the implementation of the early action scenario. So actually, not only was relating the court's judgment to the emission target, but also the pathway to achieve it. Yesterday we had the privilege to receive several NGOs dealing with climate change. And when we were speaking about climate change, they were speaking about landscape, forests, waters, reservoirs, rivers, biological diversity. Climate is impacting us through our national treasures, through our national natural values. And there are some really important findings that the Hungarian courts was able to discover. We requested the Hungarian Academy of Science to do an investigation about how the Hungarian natural surroundings are changing in the light of climate change. We also asked the national parks what have they monitored in relation to changes. And we were also very carefully studying the different strategies of different ministries, the National Sustainable Development Council, and so forth. And one issue is that the disappearance of the Hungarian plain and steppe formation, that's the well-known Hungarian puszta, the decrease of water surface and algal blooms in Lake Balaton. Let me show you a picture. The Hungarian plain, the puszta, is part of our national heritage. There are paintings, there is an approach to feel associated with this historical landscape of Hungary, and then now there are cactuses growing on it. You can see in your own eyes. And the suggestion is that the soil was very salty, but as the water is changing there, it's not going to be so salty, so it's not going to be such a flat plain, but there will be trees, there will be cactuses, there will be prairie grass, so something entirely different to what we have gotten used to. Is it involving our, is it a constitutional obligation to find a ways to preserve this element of the landscape? I think so, and the court thought so. That's also Lake Balaton, how we like to think about Lake Balaton. It's part of my national conscience. I'm associating myself and the family and everybody with Lake Balaton, and according to the realistic climate scenario, the total and open water surface will decrease permanently and significantly. So there will be much less water, and the change in meteorological conditions and the increase of water temperature is one of the key factors for the recent algal blooms occurring at Lake Balaton. There are other pictures which are not exactly as tempting to jump immediately into the river, into the Lake Balaton, and it's also part of the our natural heritage. Also forest, well, one of the, as a judge rapporteur, one of the striking thing I realized is I was looking through different scenarios of what the Hungarian Academy of Science is thinking what will happen in the near future, what the National Sustainable Development Council is thinking, and what the ministry which is associated with climate protection is thinking, and they produce official documents. And then one of these documents said, well, we are not going to have pine trees in the near future. The other document said, unfortunately, the conditions for beech, am I pronouncing it well? For beech trees is deteriorating to such an extent that they will not exist soon. And in the third document, all three are officially issued. It's not enthusiastic NGOs who are trying to shock us with little exaggeration. It was official state documents saying that we are going to lose the oak trees. And one picture is missing from here, showing what sort of forest do we have. It's either oak, pine, or beech. Then what is going to be left? And that's one of the national park is saying that there is more and more chance that the forest may change to a steppe forest thing where there are trees and then grass and trees, grass. So it might change how forests look like. And that's a beautiful Hungarian forest on the picture. A beautiful forest, of course, cutting the trees doesn't have. On the right-hand side down, it's also something not exactly the same beautiful as on the other picture. So not only we're dealing in one part of the decision with mitigation aspect, but the other part, and is at least as important or even more important aspect of the decision, is dealing with adaptation and resilience regulations. And we declare that we need instruments which are accessible, enforceable, and accountable to everybody. So there is a lacuna, a legal lacuna. We know actually very well what may happen, but we have not. There are good strategies describing what may happen, but we still have to build up the instrumental framework of protection. That is the omission part that we were highlighting. Everybody is here an expert of mitigation, adaptation, and resilience, so it's just an obligatory part of my presentation, but I don't go into the details. But again, the most important key is to find, and that was besides annulling a certain portion of the act, we requested the Hungarian parliament, and it left 1.5 years to consider it deeply, and maybe the Natural Sustainable Development Council would be a good place to try to find preparations for a new regulation, but we need clearly legal instruments that gives accountable legal ways so that appropriate measures can be done with the view to preserve the natural resources to future generations. Thank you.
Good news, there's a coffee break now. So 25 minutes coffee break until 11.
Ezeket nem lehetne, ezeket a képernyőket kicsit előrébb tenni valahogy, mert hogy tehát nem, semmi nem látszik belőle. Tehát én ott ülök a második sor.
stages. In a preliminary decision in November 2020, the Conseil d'État said two important things. First element on the admissibility of the application. The Conseil d'État has tried to apply its traditional grid, which aims to allow effective access to the courts while avoiding actio popularis. And therefore, on the one hand, it ruled that the municipality was admissible. And to rule that, it noted that the municipality is located on the North Sea shore and that part of its territory is below sea level and protected by polders. Therefore, even if the consequences of climate change are rather remote, they are sufficiently certain, and Commune de Grande-Synthe is particularly exposed to them. On the other hand, the Conseil d'État ruled that Mr. Carême, as a simple inhabitant of the city, without any other specific individual consideration, did not have a sufficient individual interest to be admissible. And in its Carême ruling of April 2024, the European Court of Human Rights rejected his appeal against this part of the Conseil d'État decision. Second element of this first decision on the legal framework of the dispute. The Conseil d'État said that even if the Paris Agreement did not have direct effect, even in a monistic country like France, it should be used to enlighten the provision made by the French authority, and in particular, the law adopted by the French Parliament, which had set the target for reducing GHG emission by 40% by 2030, and had referred to a regulation by the government, the task of specifying the pathway, the trajectory for achieving this target. And the Conseil d'État noted that the European regulation, we already mentioned this regulation, set an equivalent target for France. And maybe Hungary has better negotiated this target because obviously it was a much more difficult target to achieve for France than it was to Hungary, but it is incidental. The Conseil d'État deduced from that the legality of the refusal to take additional measures, which was the decision challenged before it, depends on the compatibility of this refusal with compliance with the trajectory, the pathway, as set by the decree adopted in application of the law. And it gave the parties 3 months to provide substantive evidence on this issue. Then in a second decision on July 2021, the Conseil d'État ruled in favor of the municipality on the merits of the case. It held that the evidence submitted to it, showing that the initial trajectory had been exceeded and that the recent improvements were due to COVID-19 quarantine, showed that the refusal to take additional measure was not compatible with compliance with the trajectory. And in a way, the government itself did not contest that, since it maintained that it was precisely preparing to take additional measures. The Conseil d'État therefore overturned the Prime Minister's refusal to take additional measures to reduce GHG emissions and ordered the government to take this measure before end of March 2022. At this point, I would like to highlight two important things. First one, on the legal framework. The Conseil d'État did not base its decision on fundamental rights, even if this issue was, of course, in the background, including with the Paris Agreement. which provides for global action to reduce GHG emission in a way that protects fundamental rights. So fundamental rights are, of course, in the background, but the Conseil d'État did not base its decision explicitly on fundamental rights. More modestly, the Conseil d'État based its decision on, in a way, a technical provision. The national law enacted by the legislative and the regulatory powers to implement the Paris Agreement at French level. In other words, the Conseil d'État ruled neither on the level of the reduction effort by 2030, nor on the nature of the additional measures to be taken. It simply noted, primo, that in order to implement the Paris Agreement, signed and ratified by France, the French legislature had set a reduction target of minus 40% by 2030, a target corresponding to that assigned by France by the EU regulation, which at that time was not in force. Secondo, that given the logic of the Paris Agreement, global commitments implemented at national level, and the explicit reference made by the law to this agreement, the targets set by the law and the regulation adopted to implement it shall have a legal effect, and therefore can be invoked before the judge in support of an appeal against the refusal to take additional measure. Second point, I would like to stress at this stage on the merits of the case. The Conseil d'État noted that the government itself did not contest the need for additional measures. It could have deduced from this that it was not necessary to annul the contested refusal. But it considered that given the uncertainty regarding the adoption of this measure, and above all the uncertainty on the timetable, it was more efficient to grant the request, to annul the refusal, and to give a deadline for the adoption of the additional measures. And it should be emphasized that the Conseil d'État did not in any way pronounce on the nature of the measures to be taken. It is up to the government, accountable before the parliament, to choose these measures. The role of the judge in this regard is simply, but this is already a great deal, to ensure that the measure taken will be sufficient for the decision to be considered fully implemented. And I believe one can see that the approach followed by the Conseil d'État and the approach followed a few years later by the European Court of Human Rights are largely convergent, not only of the issue of admissibility, which I already mentioned, but also, I think, on substance. The European Court of Human Rights has said that in order to respect fundamental rights, a state must adopt a legally binding plan to reduce progressively GHG emission to reach eventually in the 2050s the carbon neutrality as set out in the Paris Agreement, and that it is up to national courts to check that this framework first exists and second is effectively implemented. The choice of the measures to reach this goal being up to political authorities. The Conseil d'État said quite the same in substance. In fact, it has taken the parliament to its word, in a way, by giving full legal effect to the framework the French parliament and government have designed for implementing the Paris Agreement. As I said, the reduction target and the trajectory to reach it. On this base, the Conseil d'État, at the end, simply checked that the act challenged before it, the refusal to take additional measure, was compatible to this framework. And it ruled that it wasn't the case, and therefore annulled it. It left one last question, and not the least, which is the enforcement of this annulment and injunction decision. In a third decision handed down on May 2023, the Conseil d'État ruled on this issue of the implementation, execution of the decision. In a more lengthy than usual decision, it's noted that the downward trend in the GHG emission curve is due partly to external reasons. The fall, mainly the fall in energy consumption following the rise in tariffs caused by the war in Ukraine, and therefore may be provisional. Whereas the level of reduction set by the trajectory for the coming year imply an effort even higher. It noted that the government has taken a large number of measures to try and reduce the GHG emission. But it noted also that the assessment of these measures by the party and also by independent bodies, including public bodies but independent from the government, considered that these measures, even if they were useful, were still insufficient to have the opportunity to meet the target of -% for in 2030. Not to mention the future targets that will have to be set to achieve the new EU objective of -55 by 2030. The Conseil d'État therefore deduced that its decision of 2021 had not been fully implemented and again enjoined the Prime Minister to take new additional measures by end of June 2024 at the latest. And again, as I said, it did not specify which measure should be taken, as this is a task of the government. And of course, a fourth decision will have to be taken, and maybe it will not be the last. It will depend on the point that if the decision has been fully implemented or not, but a fourth decision will probably intervene before the end of this year to check whether, with the latest new measures, the annulment decision can be considered as fully implemented. It seemed to me that this decision shows both the limits of the role of the courts, but also its importance. First, the limits. The courts cannot and must not take the place of political authorities in determining what measures should be taken to implement the Paris Agreement. It is a matter of political choice and not a purely legal assessment, and therefore would go beyond the role of the courts. But also the importance of the role of judges. Climate change poses a vital risk to fundamental rights, we all know. And the European Court of Human Rights has rightly pointed out. But this risk is global, and individual action by a state alone would have no effect on the reality of this violation. It is only therefore, insofar as this effort is part of a global effort, that it can be effective. It is why, in the absence of an international court with binding powers on states, or an ad hoc jurisdictional body under the Paris Agreement, it is up to national judges to check that the state under each jurisdiction has indeed adopted a framework for action to implement the Paris Agreement, and that this framework is not purely declamatory, but is actually being implemented. It seems to me that judges have to be clear about what falls within their remit and what does not. Their role in climate litigation is a very difficult one that exposes them to criticism from both sides, but a role which is, I believe, crucial and unique. Make sure that a real plan for reducing GHG emission exists and is effective. In a nutshell, without a global framework, national efforts are inefficient, Without national implementation, the global framework is ineffective. National judges are at the interface between those two levels. Their role is therefore as essential as it is difficult. And I think it makes a meeting like this even more necessary and essential so that we can together reflect on these very delicate issues on which we are all, with which we are all confronted. And I thank you very much for your attention.
Merci beaucoup, Monsieur le Président. I would like to move to the next guest, who is we are especially also very, very moved that you could make to this conference and you have accepted our invitation. Let me introduce Justice Professor Martin Eifert, who is a justice in the First Senate of the Constitutional Court of Germany from 2023, and he is also a professor and chair of public law, especially administrative law at the Humboldt University in Berlin. Among other positions, Justice Eifert served as a dean of the Humboldt University Law School. His research focuses on questions of regulation as well as on the relationship between law and innovation. And today's topic for his presentation is the German Federal Constitutional Court's approach to climate protection, the so-called Neubayer case. Justice, please take the floor.
Thank you very much, Martha Schaber, for the very kind introduction. And thank you very much for convening this in any dimension extraordinary conference, which is extremely interesting. In face of climate change, all courts are confronted with the same dilemma, and I think Fabienne Renaud just underlined that very impressively. On the one hand, climate change is a crucial challenge that puts some of the most basic fundamental rights massively at risk. It seems to be unlikely that the guarantees of national constitutions or international human rights have nothing to say on it. Courts are required to spell out what the promise of human rights protection means in this context. And this is in line with the traditional mandate of human rights courts, which includes safeguarding those fundamental rights that are jeopardized in the democratic process. In case of climate change, the fundamental rights of future generations are jeopardized as a result of the short-term bias of democratic processes. On the other hand, climate change involves long-term changes with uncertainty, and how to precisely these changes will unfold and how they should be managed is quite not clear. The political branches are in a better position to deal with factual uncertainties and long-term management tasks. Against this background, I'd like to give you a brief overview of the constitutional requirements that the German climate policy must meet according to the German Federal Constitutional Court. The requirements, as Marcel Schabud already told you, were spelled out in the so-called Neubayer case in 2021. The plaintiffs challenged the Federal Climate Change Act in the version applicable at the time. This act was already a modern piece of climate legislation. It has taken the Paris temperature target as a basis and imposed the obligation to reach net zero by 2050, as well as a binding obligation to reduce greenhouse gas emissions by at least 55% until 2030. The Act also defined an emissions reduction pathway that included both time-specific targets as well as sector-specific ones. The Act thus defined mitigation benchmarks for specific time periods and for specific sectors such as energy, transport, building, and so on. For the post-2030 period, it left the prolongation of this pathway to the government by way of ordinance. In our framework today, the court's reasoning is far more important and far more interesting than the specific results. The objective of the court's decision was threefold. Firstly, to constitutionally enshrine the state's obligation to tackle climate change and its consequences. Secondly, to ensure that the way in which the state chooses to fulfill this obligation respects fundamental rights and freedoms. Thirdly, to ensure that the political branches are given the necessary leeway to design precisely the climate policy. It is important to notice that the court differentiated between the constitutionally required climate target on the one hand and the way to achieve this target on the other hand. The chosen target must protect the environment and fundamental rights in a sufficiently effective way. This requires a continuous reduction in greenhouse gas emissions until net zero is reached. And these are therefore positive obligations which the state must fulfill. The path towards achieving this climate target, in other words, net zero, must be designed in such a way that the unavoidable freedom restrictions associated with mitigation measures are not distributed in a disproportionate manner over time. This relates to the traditional function of fundamental rights, which is to ward off restrictions on freedom by the state. What is new is the time dimension. It adds a dimension of intergenerational justice to the traditional function of warding off restrictions. So it's not just triggering positive obligations, the time dimension. Let me explain the constitutional framework and how the court derived its conclusions some more in detail. The basic law not only includes a fundamental rights catalog, it has also a provision on environmental protection. Under Article 20A of the basic law, the state, mindful of its responsibility towards future generations, protects the natural foundations of life by legislative, executive, and judicial action within the framework of the constitutional order. Based on this provision, the court established key constitutional requirements to tackle climate change. Had there been no such constitutional provision on environmental protection, the court most likely would have developed very similar requirements based on the duty to protect fundamental rights. But how much climate action does the constitutional provision actually require? It's obviously the key question. As a first step, the decision of the Federal Constitutional Court took the legislator at its word. So we are very similar to Fabien Renaud. In the Federal Climate Change Act, the legislator had committed to the 2050 net zero target as well as to the Paris temperature target. You all know it means holding global warming to a maximum of 2 degrees Celsius, preferably 1.5 degrees Celsius above pre-industrial levels. Naturally, the Constitution is not merely a tool that is available to the legislator, rather the legislator is bound by its requirements. Therefore, the court examined whether the specification made by the legislator also complied with the constitutional requirements under 28 of the Basic Law. Constitutionally, there's no alternative to establishing that Germany be net zero in future. Given that any increment in greenhouse gas concentrations in the atmosphere further increases atmospheric warming, net zero must be reached globally, in other words, by every single state, before the temperature targets can be reached. In contrast to this, it was significantly more difficult to establish constitutional standards regarding the mitigation pathway. What is the cumulative amount of emissions that Germany was allowed to emit prior to reaching net zero? Given that global warming is a function of the cumulative amount of global emissions, a scientific assessment can only define a global emissions budget in order to achieve the Paris temperature target. As we all know, the IPCC has calculated this global budget, granted with various uncertainties which the IPCC has identified and made transparent. But with respect to this global emissions budget, there is no internationally binding way of distributing it among states. However, the international community has agreed on a reporting and monitoring mechanism for domestic efforts as an incentive to increase ambitions in climate policy. So more and more ambitions are enshrined in the Paris Agreement. The German Advisory Council on the Environment calculated a remaining domestic carbon budget for Germany based on a global carbon budget, and it used a global emissions per capita approach. In its climate decision, the court considered this budget to be a sensible starting point, but not a fixed and absolute one, for calculating the remaining emissions amount that is still available for Germany. Two factors were of critical importance in establishing the constitutional significance of this national emissions budget. First, given that climate change is a challenge that may only be tackled globally, Article 28 of the Basic Law also includes the requirement to undertake efforts to cooperate internationally with a view to addressing this issue. Existing international efforts must be promoted and must not be impeded. Second, as we know, different distribution criteria are being discussed internationally, and in comparison with other distribution keys, the per capita approach by the German Advisory Council on the Environment falls somewhere in the middle. Indeed, for an industrial nation like Germany, the chosen approach is actually rather generous, as it does not count historical emissions. With these two factors in mind, the court arrived at the following conclusion. If Germany's mitigation efforts were to significantly lag behind these requirements, this would undermine the commitment to ratchet up national ambitions that was agreed upon in the Paris Agreement. This, in turn, would be irreconcilable with Article 28 of the Basic Law. In conclusion, Article 28 of the Basic Law requires pursuing a mitigation pathway toward net zero that overall is based on the remaining domestic carbon budget. Assessed against this standard of Article 20A of the Basic Law, the challenged Federal Climate Change Act amounted to a borderline case. The cumulative amount of emissions permitted by the Act across all sectors would have largely depleted the remaining carbon budget by 2030. And by that point, given the mitigation targets that have been specified up to 2030, net zero would still be a long way from being achieved. The only reason why no violation of Article 28 of the Basic Law was established was that the remaining domestic carbon budget does not constitute a precise numerical constitutional standard, and that the court gave due regard to scientific uncertainties and the necessary political leeway. Furthermore, for procedural reasons, the complaints could not be based directly on 20A of the Basic Law. They needed to show a violation of human rights. The duty to protect offered a first step in this respect. The consequences of climate change, such as extreme weather events, heat waves, and so forth, as we all know, are a manifest threat to health, life, and property, and the state must provide protection against these threats. The positive obligation to protect these values leads to largely the same results as the environmental clause when it comes to climate change. However, in addition to limiting the rise in temperature, adaptation measures must also be taken into account here, making it even more difficult to determine a breach of duty under constitutional law. Consequently, in view of the uncertainties and the political leeway, the court has therefore, at the time in 2021, not yet found a violation of the Constitution. However, a new constitutional concept that the court developed in its climate decision is the so-called intertemporal protection of freedom. Its purpose is to ensure adequate freedom over time during the course of the constitutionally required transformation process towards a net zero economy. A free order is not just about protecting life, health, and property, but also about protecting them in a manner that leaves as much freedom as possible to everybody. This requires that the constitutionally mandated transition to net zero is designed in such a way as to not restrict freedoms disproportionately. According to the concept of the intertemporal guarantee of freedom, constitutionally protected freedoms protect against the unilateral shifting of mitigation measures which necessarily restrict freedoms to the future. It's not permissible to simply put off solving the issue of climate change. Otherwise, at some point, an emergency stop would be necessary. In other words, rapid and drastic mitigation measures that would severely restrict freedoms. Given the constitutional requirement under 28 of the Basic Law and the duties to protect human rights, net zero must be achieved by the time the emissions budget is depleted. The longer reduction measures are postponed, the faster emissions must be reduced in order to fulfill the constitutional requirements. The strict restrictions associated with such far-reaching emission reductions would be constitutionally justified at this later date, as they would then be necessary to fulfill the constitutional obligations. They are therefore no longer be successfully challenged at this later stage. Effective protection of liberty therefore requires that such serious restrictions of liberty, which are certain to occur in the future, can already be measured against fundamental rights at the present. In terms of constitutional doctrine, this is no trivial matter. According to traditional doctrine, a burden that is concrete and certain to materialize in the future is assumed to constitute an interference with fundamental rights. Such interference must then be justified and assessed as to its proportionality. In the case of emissions burdens being unilaterally offloaded onto the future, it cannot be foreseen which specific restrictions will be necessary in future, but there is certainly a high overall risk that freedoms will be severely restricted. This is referred to in the decision as an advance interference-like effect. According to the court's climate decision, such an advance interference-like effect in which the risk of restrictions of freedom is certain, even if their specific nature is not yet foreseeable, must be constitutionally justified in the same way as an interference with fundamental rights. It must therefore be examined as to its proportionality. In conducting such a proportionality test, it is necessary to ask whether the measures currently in place offload mitigation burdens onto the future in such a manner that the later freedom restrictions are disproportionately severe when considering how much time is left overall. This aims at securing a reasonable degree of freedom throughout the transition to net zero. And this is precisely where the Federal Climate Change Act fell short, as it did not define the reduction path beyond 2030, at least not in sufficient detail. Put concisely, intertemporal guarantees of freedom require a reliable transformation pathway as a foundation for timely and orderly innovations and adaptation processes in society and economy. This allows for the present protection of future freedoms. At present, there appears to be no alternative to national emissions budget and benchmarks for a reduction pathway in order to create such a reliable basis for the transformation process, which in turn is necessary to protect freedom. The Neubauer case fits nicely into international developments. Let me just briefly compare it to the decision of the European Court of Human Rights in the Swiss Klimasenioren case, in which the Strasbourg Court spelled out the requirement under the European Convention on Human Rights. A broad, very rough comparison yields the following observations. First, the focus of the European Court of Human Rights was only on reasonable reductions of greenhouse gas emissions as part of a positive obligation to protect the freedom of private and family life under Article 8 of the European Convention. There was no assessment as to whether the way in which the transformation pathway unfolds over time is compatible with protected freedoms. In terms of the duty to protect, the European Court of Human Rights follows a very similar approach to that of the Federal Constitutional Court and to the Grand Cert decision of the Conseil d'État. Given that there is no environmental protection provision in the European Convention on Human Rights, the issue of climate change is dealt with in terms of the consequences of climate change on the human rights guaranteed of the Convention. Net zero is a binding goal that is also required by human rights in light of the Paris Agreement, and to ensure this goal, a binding mitigation pathway must be defined. Such a mitigation pathway requires measurable interim targets, and the European Court of Human Rights highlights the importance of any such specification being based on a carbon budget. Fourth, the European Court of Human Rights does not specify the exact size of the carbon budget, but it does set out strict requirements in terms of monitoring and updating mitigation targets and informing the general public as to the current state of emission reductions and respective developments. There is an unmistakable parallel to the monitoring and evaluation approach used in the Paris Agreement. Fifth, the establishment of such a system of safeguards is binding for the Convention states, and the European Court of Human Rights carries out a strict review in this respect. However, it falls within the state's discretion to decide on the specific measures employed to reduce greenhouse gas emissions. Just as in the Federal Constitutional Court's climate decision and the Grand Cyr decision of the Conseil d'État, it is a binding task imposed on the political branches of government to combat climate change, but defining the precise pathway is left to the political branches. Let me conclude briefly and summarize the key points. Fundamental and human rights law impose an obligation on states to guarantee an effective and rapid shift to net zero economy. This requires taking rational and well-planned steps in terms of defining and communicating emission reduction targets. The chosen mitigation pathway, including the interim targets, must be based on the Paris Agreement. The question as to the precise content of relevant fundamental right obligations has not yet been fully resolved. The political branches are free to design the individual policy measures. Fundamental rights thus do provide an answer to the question raised by climate change. The courts act as a driving force for fundamental rights protection, but it's up to the political branches to define the pathway to reach that aim. Thank you very much.
Thank you very much, Professor Justice Martin Eifert, for your fascinating presentation. The next speaker is a long-standing friend of Hungary. I would like to remind this audience that over a decade ago, there were considerations that maybe there is no need for an ombudsman for future generations. And a little branch of international scholars with Professor Marie-Claire Cordonnier-Seeger in the front line and Professor Marcus Gehring next to her were coming and trying to explain to all potential level that how important it is to have an institution like this. And their wonderful contribution was an important benchmark in being able to safeguard this very important institution. And later, the future ombudsman decorated Marie-Claire with a very specific medal in which he expressed the thanks on behalf of those who try to safeguard the fundamental rights of present and future Hungarians for that wonderful involvement. But of course, in the next 40 minutes, I would like to introduce briefly what are the involvements of Professor Marie-Claire in different levels. No, I will take it very short, but it could take very long. Professor Marie-Claire Cordonnier-Seeger is a professor of law and governance on sustainable development and serves as chair in sustainable development law and policy at the University of Cambridge. Professor Cordonnier-Seeger has years of experience advising the United Nations, international organizations, and nations on implementing the Sustainable Development Goals. Among other positions, she is the Senior Director of the Center for International Sustainable Development. And today, she's having a fascinating topic here. The title is Climate Courage, Contributions and Compliance, Advancing International Law for Future Generations and Our Natural World. Professor Seeger, please take the floor.
Sorry. Just do not touch the laptop. Anything might happen. I'm just waiting for the directors of all the Indonesian institutions of Mexico to start laughing.
No.
Right, I'll just sit there. Well, while they're searching for the technical side, I will just say that I feel it is a great honor to be here and to be part of this discussion with distinguished colleagues, particularly to be hosted again in this beautiful building, and especially, of course, to be able to stand on such strong foundations of some of the leading courts and indeed countries of the world. This morning with Professor Sabo, with Marcel, and with the other distinguished judges and professors who spoke about the new Hungarian decision, and then this afternoon as well with you bringing some light to our understanding with the experiences in France, in Germany, and of course in one of my countries, Switzerland, and speaking from the view of the European Court as well. It's truly an honor to join you and to perhaps begin a group of experts who have been invited to comment on some of the trends and challenges ahead for us. And from my side of it, I suppose I've been asked to speak about the international law side of things, and then I know my colleagues will also speak about administrative law and also give a comparative view on some of the constitutional elements. So I'll do my very best with the mandate I've been given, as always, in service of our gracious hosts and particularly in such distinguished company. I think in this group, it only bears a mention and warning and alert that the problems that we are facing are not just problems for a community on the edge of an ocean that is rising, but also problems for the world, the globe. And they are problems that we are facing that are intertwined with and desperately and frighteningly intertwined with other equally serious global challenges, human development pressures, the shattering of planetary boundaries, a volatile and unequal and indeed fragile world economy. And the global challenges, the ones that cannot be solved by just, as my justice and professor colleagues have just emphasized, by just one country or one government alone, or indeed one court. These global challenges include the rising intensity of climate change due to increasing greenhouse gas emissions and temperatures, unequally distributed worldwide, and also the rising floods and heat waves and extreme weather events that we are facing. And I speak for a moment as a Canadian who fought for the protection of the forest in my country and is watching as those forests right now in British Columbia are burning. And I think all of us now know situations like this. Professor Sabo, Marcel, your lake that you are worried about desperately. The people who have brought cases who are questioning their right to life in many cases. The Commission of Small Island States and the other members of the IUCN World Commission on Environmental Law that Professor Voigt, Christina, is working so closely to assist. The global challenge is also, however, and here in the Hunter's Hall with I believe nature is sort of winning in the back wall. I'm not sure the humans have quite managed to clinch that one. But we have our fisheries and we have our river surrounding us. We also must take into account the rising biodiversity loss and forest degradation that is related to that climate change challenge and just as significant. Current species extinction rates ranging from 100 to 1,000 times faster than they should be worldwide. Global biodiversity hotspots and forest loss increasing every day. And the rising biodiversity loss in freshwater and marine ecosystems as well, and the small patchwork of marine protected areas that we can rely on. The challenge that still is before us to reach 30% by 2030 in protection. And the rising land and soil declaration on which our agriculture and indeed our right to life depend. In this situation, having been asked to address international law for future generations in our natural world, I think it is fair to say we're not doing a great job, are we? There's still a lot to do. And in our own context, the conflict, the geopolitical instabilities, the rising levels of people, 2 billion living in countries affected by fragility, conflict, and violence by 2030, 84 million forcibly displaced. It is a frightening global context, one that requires that courage to look in the eye and take action. And indeed, international responses to complex challenges and impacts are being, as much as we can, with the courage of some courts and some colleagues, mobilized. These global wicked problems are increasing in severity and impact, but the risks are not truly surprises. The international community has been examining scientific data, raising the alarm, and struggling to negotiate responses for as long as the United Nations has existed, and indeed much before. And this has led to clearer definitions of problems, general commitments to cooperate, fragmented, coherent, or not, attempts to act. We have, of course, and this will not be a surprise to those in this hall, an international policy process on sustainable development. From those many moments of adoption of sustainable policies, whether, as my colleague explained last night, in Hawaii, on the island of Maui, with particular irrigation and water management laws and policies that date back thousands of years, or indeed the aqueducts and the management of soil in the Swiss Valley where my family comes from, or indeed also the practices and natural resources sustainability policies that my father's people in the fenlands of Cambridgeshire used to follow prior to the draining of the wetlands. We have seen many of these policies come forward in a global movement for sustainable development that is part of our international policy context. And in international law and policy, we're not restarting from zero every time. Despite the nearly 200 countries, different polities, courts, governments that have to come together to address these global challenges, this global joined up, connected crisis. Indeed, we have, of course, rather than restarting from zero, a global common agenda. We have, as Madame Catalina this morning reminded us, the Sustainable Development Goals and a commitment to transformation globally towards sustainable development, away from a model that undermines human rights, undermines the natural world, and undermines the possibility of an economy that is able to truly address poverty. These 17 goals, building on the Millennium Development Goals with 169 targets, measurable with admittedly rather weak indicators, provide a common framework to facilitate cooperation and action. And for all countries, developed or developing, they offer a succinct set of public policy priorities and time-bound targets. But is this agenda global policy only or also law? And here I'd like to recognize especially my colleagues from the Center for International Sustainable Development Law and many others, professors who are with us today and around the world active in this area, because they're not just policy, are they? Behind every one of these Sustainable Development Goals, there are binding treaties with cooperation mechanisms, scientific clearinghouses, capacity building agendas, and financing as well. There are more treaties than people sometimes give us credit for. We've been working very hard in international law to give you the support that you deserve to be able to step forward as courts with courage. And if we look at these global treaties, and how they link to the Sustainable Development Goals. And we take seriously those commitments and also the mechanisms that are set up in these international structures to assist us in addressing these frightening global crises that we face. We need to do this with a view of law, which is reflected in the discussions this morning, and also, of course, in Professor Szabo's reminder that this is, in some cases, customary law, principle at play, or this is indeed a binding international treaty that is being implemented. And so I take this, and I'm not going to go into detail here, from a perspective of legality and legitimacy, an interactional legal theory that is more than just a black-letter reading of the law, more than just judicial principles, but actually a consideration of whether or not we can achieve the effects that our treaties are seeking to achieve. And if we can't, we go back and we change the regime, like we had to with the Kyoto Protocol and the Paris Agreement, in order to get closer to the ability to implement. These rules are transforming practices and constituencies, but also being interactionally transformed on all levels themselves. And indeed, that means taking into account the many international institutions on sustainable development that are acting together to try to address the binding rules, and also the principles that are recognized by the International Court of Justice, the Permanent Court of Arbitration, the International Tribunal on the Law of the Sea, and the World Trade Organization, among many other international courts and tribunals that are assisting us to understand and interpret the international law. And in the light of those interpretations, these extraordinary judgments of which we have been speaking this morning. So moving towards sort of a conclusion, I want to briefly touch on one other piece of the puzzle. When we're trying to achieve Sustainable Development Goal 13, take urgent action to combat climate change and its impact, we look, of course, to the United Nations Framework Convention on Climate Change with its objectives, stabilization of greenhouse gas concentrations in the atmosphere at a level that prevents dangerous anthropogenic interference with this climate system, or as Professor Voigt has said in international experts meetings and various publications, a stable climate system. And the cooperation mechanisms, reporting, national communications, compliance mechanisms that are needed to achieve this. The Paris Agreement, with its focus on ratcheting up ambition, not just the pledges on mitigation adaptation, but the incentives through finance, technology transfer, education, facilitative dialogue, and other cooperative measures, and the accountability that backstops with transparency, reporting, common baselines, peer review, periodic stock-taking, public participation, and that compliance committee. These are essential pieces of one regime with one sustainable development goal that is so crucial, and that these decisions are helping us to address. As we move forward with the Paris Agreement, the courage that came up earlier becomes even more important. And as we look at the pledges that we have to date and the results, even if they're all entirely implemented, we realize we're not yet close to where we need to be. And the decisions, such as the one that was taken this week by the Hungarian Constitutional Court, are desperately needed, as are many, many more. Indeed, one of the studies that we have done shows that climate law and governance will be crucial for success in this process if we take our regime and its interactional implementation seriously. Out of 186 NDCs in the initial round, 169 explicitly prioritized legal or institutional reform. And the question there, of course, is, well, what does that mean? Our colleagues this morning mentioned it is to the government to come up with the right climate policies and laws. And of course, it's to us as professors and researchers and others, advisors to UN countries in their implementation of the Paris Agreement, to assist in that process. And we find that for mitigation alone, there are many laws and institutions relevant to mitigation which are also crucial in that transformation that I spoke about earlier for the Sustainable Development Goals. Laws on renewable energy, on land use planning, on water mining and forest management, transportation laws, including for zero emission or electric vehicles, pollution pricing and controls, including for black carbon or CFCs, as well as environmental impact assessments or registries, and access, of course, to our courts, where we disagree. And at the same time, taking the Paris Agreement seriously, Article 2.1, we look especially at climate adaptation and resilience laws, and again, it's not just early warning and assessment, disaster risk reduction, response and management rules. It's also land use planning, zoning, coastal planning, flood defenses in the fens where I live today. Not to mention construction and infrastructure regulations. I can see why, honored justices, your court said it's to the government to get this right. We will simply require you to do so. The rules and regulations for resilient agriculture that include care for food safety. This is not a simple process, and climate resilience does involve indeed natural resource management laws, water resource management, and among many others. Finally, an important piece, of course, when you look at the global situation, is the law and governance for climate finance, changing the direction of an entire world economy that had projected itself to be based on fossil fuels. If we know that that is not possible, the science is telling us that the costs are too great, the impacts will be too enormous and too significant, the planetary boundaries shattering, then how do we change our finance, as Article 2.1c of the Paris Agreement requires us to, in order to be able to support a sustainable development trajectory? And the laws and regulations there, regulating capital markets, finance, fossil fuel subsidies, access to financial services, even just the what they call a haircut, the capital cost on renewable versus a fossil fuel investment, even just that, you know, from a 35% surcharge because renewables is somehow risky to something else when we take into account the climate impacts. Access and benefit systems, disclosure rules for investment. The key here is that some countries can indeed go fast. But if you want to go fast, as my son's godmother, Wangari Maathai, Nobel Peace Prize laureate, and the founder of the Green Belt, billion trees movement across Africa, used to say, if you want to go fast, you can go alone. But if you need to go far, you have to go together. And so in order to take us in the direction of going far together, I'll offer just a couple of closing thoughts. First, we're engaging a climate law and governance community worldwide. Thousands of lawyers and those working on governance systems coming together alongside the COPs every year. Indeed, in Baku, we were joined by 3,200 registrants from over 150 countries to talk about how they can make those changes to the law that I just spoke about to address that global crisis that we started with. And indeed also the pledge that was taken in Glasgow, which was met, I was relieved to say, in Baku, to scale up from 600 to 6,000 registered climate lawyers practicing worldwide. And we'll need many, many more. I mean, think about the criminal bar alone, 22,000 lawyers or more in my country. We think 6,000 is a huge achievement from 600 maybe, but one country, the criminal bar is 22,000. We need that capacity for those legal and institutional reforms that are crucial for how many was it, 169 NDCs to achieve them? Where are those lawyers going to come from? Do our bar associations have climate committees? They don't, do they? So there's a lot of work that needs to be done by the climate law and governance community. Speaking of courage. And even if we do achieve every target, mind the financing gap, as they sometimes say in the British Tube. 2.5 trillion needed annually in developing countries alone in order to achieve even just some of the Sustainable Development Goals. If we do manage to meet our financing targets, we agreed in Baku, you know, 300 billion a year by 2035 out of 1.3 trillion needed. We still have a further gaping chasm in the road ahead. And that is a creativity, capacity, and courage chasm. If the necessary resources can be mobilized and accountably managed, further gaps are just thrown into sharp relief to achieve our binding obligations of these treaties. New research and knowledge is needed for the creativity. New awareness, education, and skills development is needed for the capacity. And renewed ambition courage, including the courage of our judiciaries, is needed for those legal and governance reforms. And this is not just a role of parliaments like this beautiful building and the people that have spoken to us from our courageous Hungarian colleagues. This is not also just a role for our judiciaries, although they are indeed very brave and very honored. It's a role for universities and colleges and for research and innovation institutions who are assisting those governments and international organizations. And I don't think we're doing enough yet. I really don't. As a tiny piece of that puzzle, I want to especially recognize the other editor of our book, Courage, Contributions, and Compliance on Climate Law and Governance, Professor Christina Voigt, who's here with us, of course. It's an honor and pleasure to work with her and with Professor Zunaida Musawadiwala from South Africa on this important contribution to the debate. It takes an international interactional theory perspective. It looks at the challenges we're running into in implementing the Paris Agreement at the national level, and it seeks to learn from them to suggest new ways forward at the international level and then back down again. Transformations of the regime and the system for compliance and implementation. I should also recognize the work of Professor Judge Marcel Sabo, a dear colleague and indeed collaborator for many years, and Professor Alexandra Harrington, together with whom we edited Intergenerational Justice in Sustainable Development Treaty Implementation, Advancing Future Generations' Rights Through National Institutions. You see a pattern here, don't you? We looked at the national institutions struggling to implement intergenerational justice, including the decisions of those who review parliaments, laws, and also courts, and then how that again informed that global constitutional and international customary legal principle as per the Hungarian Constitutional Court as of 2 days. And those two contributions to the research and the creativity agenda are certainly not enough. So I'll conclude with an invitation. It's an invitation to a new set of online courses and certificates at the University of Cambridge. As part of my chair, we offer a Democratizing Education for Global Sustainability and Justice program. These courses, for those accepted, are absolutely without charge. So there's a bursary for, at the moment, the 9,000 people who've taken them, mainly those in the public service, law and policy leaders, current and future, in highly climate vulnerable countries who have been signing on online with us. But they're open to everyone, and if you can tell your colleagues, they would be very, very welcome to join us. We have 186 course ambassadors from 96 countries spreading the word, and over 9,000 alumni trained so far out of 32,200 contacts in the highly climate vulnerable countries and beyond. And you would be welcome to join us online to try to do our best to deal with that capacity chasm. I'll conclude with a note on courage. The call is for creativity, courage, and capacity, scaling up the research, providing excellent independent advice for law and policy change, including reasoned and visionary judgments, such as we've heard about this morning, guiding legal systems and societies, and building capacity, strengthening awareness, education, and career skills. The last slide is a quote from an author and novelist that's been adapted. Historically, crises have forced humans to break with the past and imagine our world anew, and these ones, the ones we started with, are no different. They're a portal, a gateway between one world and the next. We can choose to walk through it, dragging the carcasses of our prejudice and hatred, our avarice, our data banks, our dead ideas, our murdered rivers and smoky skies beneath us. Or we can walk through lightly, with little luggage, ready to imagine another world and ready to fight for it. Thank you.
Thank you very much, Professor Kornei-Zéger, for your fascinating and encouraging lecture. And now I would like to introduce my justice colleague from the Constitutional Court, to whose brilliant analysis we are all looking up to. And just a few words about him. Justice András Patyi is a member of the Constitutional Court from 2023, a former judge and vice president of the Curia of Hungary. He also served for 5 years as a president of the National Election Commission. András Patyi is also professor of public administrative law at the Ludovika University of Public Service of Budapest, where he was the first university president of this institution between 2012 and 2018, and currently he is head of the Doctoral School of Public Administration Sciences. His main fields of research are the legality of public administration, the administrative judiciary, and questions of administrative procedural law. And I ask Professor and Justice to head your lecture.
Thank you very much. I need some technical help as well. That's it. Okay. Thank you very much. Honorable Presidents, fellow justices, judges, professors, dear ladies and gentlemen, the closer we are to the lunchtime, the more difficult it is to start a presentation and to hold it. It is difficult to find the room for my thoughts, as the main topics of my presentation have already been not only mentioned but also explained in detail. But I try to do my best, and I leave it to your judgment whether I was successful or not. So please excuse me that there will be some repetitions of previous thoughts. At the end of my presentation, my short speech, I'd like to emphasize and express two general suggestions, not directly to climate or environmental protection, but to constitutional and administrative interconnections. So let me start it with pressing one of the buttons. Okay. So I have a Latin quotation I always use at the beginning of my lectures. Nauta de ventis de tauris, I will translate it into English. Nauta de ventis de tauris narratarator, enumerat miles vulnera pastor oves. The sailor is speaking about the wind, the farmer is speaking about his oxes, the soldier is counting his wounds, and the shepherd is counting his sheep. For me, it means that every man talks about the topic he is an expert in. I'm mainly an expert, or mainly trained in the judicial review of administrative decisions. That's my main field of research, and I also deal with the constitutional requirements for that. And the other introductory thought is that I have a long title, and when the title is too long, the presentation should be shorter. I like to speak about these topics: the general approach to constitutional requirements on protection and the rights to be protected, some thoughts on administrative instruments, challenges, prospects, and solutions. I'd like to repeat the main topics of our fundamental law on public administration. The efficiency of state will also be mentioned, and finally I'd like to talk about the three main pillars of public administration and the Constitution. So environmental protection in our Constitution, in the Hungarian Constitutional law, has a number of provisions. The Article P of our fundamental law has been mentioned and analyzed before. And I don't want to talk too much about that. I only want to emphasize that this provision is rooting in the principle of intergenerational equity, which is especially mentioned in the preamble of our Constitution. It has a special name, national avowal, as it is translated into English, but this is a long and structured preamble for the Constitution, serving as a framework of interpretation as well. And this preamble emphasizes the principle of intergenerational equity. We also have a right, a codified right to healthy environment, and what is also have to be mentioned that the Hungarian Constitution recognizes the principle of a sustainable development in a special circumstance, in a special textual background. It appears with the peace and security. Our Constitution mentions peace and security and sustainable development of humankind as the main fields of international cooperation. Of course, constitutional provisions, the constitutional framework firstly play an internal role. It firstly talks to Hungarian citizens, talks to subjects under Hungarian law, but of course these provisions, this framework must be adaptable to international agreements and global environmental challenges. On the other hand, the constitutional framework or the constitutional background should be flexible enough to incorporate new technologies into national environmental strategies and provide appropriate incentives for their adoption. If we look at the types of administrative instruments, what public administrations in general can use, or what public administrations, governments use in protecting our environment, these, in my opinion, these are the main administrative instruments. I don't think that there are too much new in this listing, but we may say that the majority of these instruments, the regulatory instruments, permitting and licensing, enforcement and sanctions, the environmental impact assessment process, are mainly linked to the power what public administration regularly uses in states under the rule of law. What is also should be mentioned that amongst the administrative instruments we can find policy and management instruments, showing that public administration is not only about permitting, licensing, and sanctioning. What are the main challenges these instruments, the implementation of these instruments face? First and foremost, we have to mention political and economic pressures. Environmental policies, environmental administrative instruments often face challenges from powerful economic sectors, agriculture, energy, and construction. These sectors have significant political influence. Implementation and enforcement. Despite the robust legal framework we have, and the majority of the European countries have, these countries face challenges in fully implementing and enforcing environmental regulations. Public awareness and education should be also mentioned. While public participation is enshrined in European countries' law, greater efforts are and will be needed to raise awareness about environmental issues. These issues, including administrative instruments, shouldn't be regarded as the business of lawyers, business of public administrators, business of court decision makers or judges. What we also should concentrate on is the capacity and resources. Administrative bodies may, and sometimes not only may, but in fact lack the necessary resources, expertise, and personnel. And finally, let me point at the technological advancements, by what I mean that there are promises. We have renewable energy technologies, carbon capture and storage. These hold great promise for addressing environmental issues, and new technologies and technological advancements should be incorporated into public administrative policies and strategies. When we look at the machinery of public administration, we see that our fundamental law has several provisions about how public administration, how Hungarian public administration should be organized, understood, and managed. And it is not the specialty of the Hungarian fundamental law as countries, states under the rule of law have a number of provisions, a number of constitutional provisions about public administration, but these constitutional provisions mainly are concerned with state decisions and the decision making, the remedies, limits of public power. Our fundamental law says a bit more. Let I mention firstly the rule of law rule. I mean, Hungary is an independent and democratic state under the rule of law, says the constitution. I think the better translation would be Hungary is a constitutional state, a Rechtsstaat, because this expression in Hungarian language came from the German language. Of course, we have a right to an effective remedy against decisions of all kinds of public authorities. But we have an additional right, the right to good administration. That means everyone has the right to an impartial and fair administration, administrative decision-making of one's case. We have the right to a properly reasoned decision, and our constitution is talking about the responsibility for damages by the administration. We have the right to file a complaint to any authority of the state, and of course the constitutional fundamental law ensures judicial control of administrative decisions, both as a personal right and of course as a court's power. The participation in local governance also by local referendums is provided for the Constitution. And finally, let me stress that there is an efficiency rule, an efficiency requirement in our Constitution that leads us to the next page. So our Constitution mentions the efficiency of the state in a special textual background, saying that the state shall strive to use the latest technical solutions and the achievements of science to make its operation efficient, raise the standards of public service, improve the transparency of public affairs, and promote equality of opportunity. For the first sight, this provision can be understood as one that speaks about the role of science and the role of technical solutions. But for me, it also speaks about the operational efficiency of the state and leads to the concept about the constitution. What do we think about a country's constitution? What kind of document is that? If we look at the constitution as a political document, we may say that this is only a declaration. I mean, the Hungarian parliament declared that the efficiency of the state is important and the technical solutions and achievements in science should be used. A political document can contain several statements, messages, pronouncements, declarations. But if we look at the Constitution, and I invite all of us to look at our Constitution as a legal document, which is the supreme law of the land, the law of the laws, that will mean that it contains only norms, no declarations. And from norms come either rights or obligations. If the Constitution contains a provision about efficiency of the operation of the state, it should be understood and followed as a legal order or legal obligation. This is a must. If we talk about the efficiency of the operation of the state, we also understand public administration, because public administration as a whole is the part of the state. As in the European Union law, we understand and we follow the ever closer union, we may understand this provision more and more efficient state, ever more efficient state, if it is not completely incorrect in English. I think it is not. So this is a must for the state, for the Hungarian state, for all the branches of the government, for all the organs, bodies of the whole state organization. They should be efficient and year by year more and more efficient. What are the elements, what are the pillars of public administration? Is it correct that we only think at public administration as a decision maker or a group of decision makers? Is the decision making the only heart of public administration, as the famous American scientist Herbert Simon emphasized? From administrative sciences in the last 10-15 years came new winds saying that public administration, understanding public administration cannot be narrowed to decision making anymore. It cannot be narrowed to legal branch or legal pillar of that. There are three equal pillars, three equal aspects of public administration, which are in mutual existence and interaction. Of course, there are different approaches. The first is the legal pillar, where laws, values, guidelines for activity of the public administration, obligations, limitations of public power, saying that public administration is subject to the law, including in the law we include the constitutional norms as well. But the political pillar is equally important, having at least two approaches in itself. Politics of how leads us to a small and efficient public administration which is not involved in policy matters. And if we think about or talk about politics of what, that derives from the role and functions of the state, which leads us to the notion of big government or great government. Of course, politics always control and direct management, which is the third pillar, the managerial pillar of the decision making, motivation, commitment, service, quality, questions of how to accomplish certain goals. I missed an M, I'm sorry, from the word accomplish. So these three pillars are equally important. They are in mutual interaction, and when we think about public administration, we have to think to all of these three pillars. When we think about in the Constitution in our mind, we have to do the same, saying that public administration should be regarded as a whole with all these three pillars, and the Constitution should be regarded as a complex or complete document. Let me give just an example for that. We speak about intergenerational equity, which is rooted into the Hungarian Constitution, the fundamental law. That document also mentioned the responsibility for future generations. We have to also bear in our minds that there are other constitutional responsibilities. For instance, when we think of elements of environment, they are always in the property of a legal subject. There is always an owner, private or public, the state itself, or other powerful owner, or small or big, whatever. Article 13 in our Constitution says that everyone shall have the right to property. It doesn't mean that the Constitution itself gives pieces of land or expensive car to any other citizens. It gives the possibility to become an owner. But it also mentions that property shall entail social responsibility. Social responsibility. If all the owners under the Hungarian Constitution have the right to property, means that all the owners under the Hungarian Constitution owing elements of environment are under a constitutional responsibility. For me, it is the final source for intergenerational equity, saying if you have something, you have obligations. And these obligations oblige you not only the present, but also to the future generations living here. It led me to the conclusion that intertextual relations are overly important in the Constitution because in the constitutional courts, in constitutional litigation, we always think of constitutional rights that are limiting each other. That's the hard core of the test of the constitutional litigation. For me, these provisions are not only limiting each other, they also amend and strengthen each other. These two other functions of the constitutional provisions could be or should be more important in environmental, climate, and landscape protection. And these textually interconnected provisions that amend and strengthen each other should govern all the three aspects of administration: the policy making and doing of politics. I mean the content of policies, the management of the cases, the quality of the management, the decision making, and of course the limitations of legal aspects. And what are the two general suggestions I wanted to emphasize? They are very simple, and I've already mentioned them. So I like to suggest that we should interpret constitutional provisions in a different way. And besides doing that, we should understand public administration always in the broader sense, understanding always the three pillars, not only legal limitations, but also the content of policy and quality of management, especially when we talk about climate and when we talk about the possibilities and rights of next generation. Thank you very much for your kind attention. This is expressed in Hungarian. Thank you very much.
Thank you very much for this fascinating and thought-provoking presentation. And now my task is to introduce the last speaker of this panel. The most important thing I would like to speak about her is that when we received the task at the Constitutional Court to deal with the climate case, she jumped into that case to do the preliminary research. You have met yesterday Sándor Szemesi, who continued his work after Péter Láncos involvement as Dean of Foreign Relations of Pázmány Péter Catholic University couldn't make it possible to devote her further services to the Constitutional Court. Big loss for the court. But the first thing what we were doing is that we were looking for the decision of the German Constitutional Court. And a lot of appreciation, of course, to the Korean decision, we appreciate it extremely highly. A lot of admiration to the French decision, we naturally appreciate it very, very highly. But all those here know that the Hungarian legal system is having special relations with the German one. You know that for a very long period of time we were living in a special state structure where a part of the state was a component factor of the so-called Holy Roman Empire, so Germany, as it was called at that time, and the German legal traditions were actually step by step having had an impact to Hungary, which didn't have a legal connection to that empire, but nevertheless had the same federative state relations with Austria, and thereby German and Austrian legal considerations have step by step entered the Hungarian legal thinking, and it has still a very big impact on the Hungarian civil law, for example. So Based on that, I asked Professor Peter Lántos to investigate the decision of the German Constitutional Court and make a comparison of what was requested by those who presented their claims at the German court and what is requested at the Hungarian court. And now, as we have both decisions in our hand, she will be able to compare the two decisions, which is, I think, a fascinating and really interesting thing. And I really want to say a lot of things about her, because she's a wonderful academic and a great lawyer, but she's pushing me out from the scene, and I don't want to take away more of her time. So please, Professor Lántos, take the floor and have your presentation.
Thank you. You have not only taken away some of my time, but my topic as well. But I hope I can still say a few things. And I am really humbled to speak after such esteemed colleagues, and also conscious of standing in between you and lunch. And so I will be brief. And this is aided by the fact that I only received the decision of the Hungarian Constitutional Court 2 days ago. So I couldn't go that deep into the decision. But yes, it is true that I started working on the petition, and then when I left the court, then obviously my esteemed colleagues went on to go deeper and draft the decision in the Hungarian case. But before I start, allow me a personal note. About 25 years ago, my grandfather, who was a keen industrialist, he was a mining engineer, he handed me a book entitled The Limits to Growth. And he said, this is highly important, it has to be on your shelf, and this book is going to affect great change. The book was from the 70s. But I am really proud to be here today to speak about two decisions that may also have such an impact on our world and the law, hopefully, and may protect the environment on the long run and also the interests of future generations. So in what follows, I would like to speak about a comparison of the German Klimabeschluss and the Hungarian Klimahatározat, as I shall now dub it. And before I do that, I would first like to speak of the role of German constitutional jurisprudence in Hungarian constitutional thinking, because some of you may ask yourselves why we concern ourselves so much with the German decision. And then I will just go into a brief comparison of the Klimabeschluss and the Klimahatározat, looking at the petitions as well. That is something that I had more information on, and then comparing certain pillars of the decisions. And then I will go to brief, quite obvious conclusions. So, as Professor Szabó has already mentioned, German constitutional thinking is highly important for us in Hungary. One of the reasons is because of the Austro-Hungarian monarchy and our shared legal traditions. But also, and I think this is highly important today in the 21st century, is our knowledge of the German language. While unfortunately the knowledge of German is decreasing quickly in Hungary, it is an important, has always been an important language in administration, but it is also a very treasured and important minority language in Hungary. And it is something that allows us access to German law and German constitutional jurisprudence. And you will find several references in Hungarian constitutional decisions to Bundesverfassungsgericht Entscheidungen. So you will find a lot of them, exactly because of this linguistic access. And perhaps based on all of these reasons, the Hungarian Constitutional Court has traditionally looked very keenly on Bundesverfassungsgerichtsentscheidung during the last 30 years. And I think it is this tradition, and it was these reasons why the Hungarian petitioners actually referred to the Klimabeschluss of the German Constitutional Court. So why compare these two decisions apart from, the clear references to German constitutional jurisprudence that I already made? Well, just 6 months after the Klimabeschluss was adopted in Karlsruhe, petition number 2/3536/2021 was submitted to the Hungarian Constitutional Court by the 50 members of Hungarian Parliament. And similarly to the petitioners that proceeded before the Bundesverfassungsgericht, the Hungarian petitioners also challenged the National Climate Act for insufficiency and for non-specific emission targets. So the petition was very similarly structured, but it also explicitly referred to the Klimabeschluss. And it also alluded to the fact that the constitutional legal basis that are invoked in the Klimabeschluss by the petitioners are very similar to the ones that we have in the fundamental law. So let us first look at the nuances coming to our comparison that are different in the petitions, and then go on to the similarities between the decisions. So the differences that stand out are related to procedural questions and expediency. So while in the case of the German petitioners, we speak of private individuals residing in Germany and outside of Germany, as well as environmental organizations that were not admitted in the end, in the Hungarian case, the petition was submitted by 50 members of parliament who have a constitutional and statutory right to submit these types of petitions to the Hungarian Constitutional Court without having to substantiate any impairment of rights or interests, making it easy to try and challenge the law from this perspective. We do not have an actio popularis. And the other thing that is a slight difference between the two petitions is that the German petition sought the annulment of the Klimaschutzgesetz based on unconstitutional restriction of rights, while the Hungarian petitioners also sought the examination of the Climate Act and its possible conflict with the International Treaty of the Paris Agreement. And if we look at the fundamental rights that had been invoked in the case of the German petition and the Hungarian petition, then we will see a few parallels. However, the parallels that stand out relate to Article 2 of the Grundgesetz, the right to life and physical integrity, and Article 21 in the fundamental law on right to physical and mental health. Obviously, the Grundgesetz also has an Article 20A that you have referred to, which we can possibly put in line with Article 21 or Article P of the Hungarian fundamental law. So now I come to the comparison of the decisions briefly, and a comparison is not only justified because of the similarities in the two decisions, but also because if we look at the main pillars that are holding the structure of environmental protection in the decisions, we can say that these can serve as a model for other courts to follow in the future. So how did I select the factors of comparison? Well, I must admit that these factors were gleaned from the scholarly literature that has emanated after the adoption of the Klimabeschluss. And in particular, I looked at the Verfassungsblog, which quickly tried to digest the Klimabeschluss at the time. So I'm going to look at just a few comparators, which I think are of fundamental importance and can be very important vehicles for other courts as well to further their environmental rights protection on a constitutional level. So one such basis of comparison could be the framing of future risks as constitutional infringements in constitutional jurisprudence. In the case of the Bundesverfassungsgericht, we have the Eingriffsähnliche Vorwirkung that you have already alluded to, the advance interference-like effect, that has been a wonderful vehicle to deal with fundamental rights restrictions that have not yet taken place. And this is done by the figure of saying the omission of the state will set processes in motion that will cause irreversible harm. And if we don't deal with this type of risk now, then all remedies in the future, all claims will be futile. So already this Eingriffsähnliche Vorwirkung shall be a basis for proceeding under the Grundgesetz. In the case of the Hungarian Constitutional Court, the court does not explicitly state that there's a clear and effective restriction of fundamental rights that had been invoked. Instead, it arrives at a very similar conclusion by saying that the omission on the side of the legislator violates Hungary's objective constitutional obligation to safeguard fundamental rights. Another factor that is very important is the willingness of the courts to balance generational rights and interests. And in the case of the Bundesverfassungsgericht, what we see is that the court refers to Article 20A, and it says that this article does not say that future generations' interests would take precedence over those of others, but it does say that these interests must be balanced with the rights of individuals who are present now. And it does say, as Professor Eifert has already mentioned, that the freedom of action should be distributed proportionately between the generations. And similarly, the Hungarian Constitutional Court also comes to a conclusion that alludes to this. But it perhaps goes even further by saying that present generations today have three obligations: to preserve choice, to preserve quality and access for future generations. Choice, meaning choices in plural, no straw man options. Quality of environment in the quality that we have inherited it from our previous generations, and a possible restriction for present generations to these natural resources in case the future generations' interests would be violated. And I think this Hungarian requirement to preserve the quality of environment at the same quality as we inherited it is extremely stringent, and I hope it can be enforced as well on the long run. And now I come to the role of science. We have an esteemed colleague here who knows a lot about the role of science in litigation. Well, it appears here as well, and the Bundesverfassungsgericht actually specifically says that while there are scientific uncertainties surrounding climate change, but scientific predictions must be taken into account by the legislator when legislating, and it does give rise to a duty of care on the side of the state. And incidentally, science actually becomes a yardstick for reviewing legislation as well. So the Bundesverfassungsgericht itself is relying on scientific facts when reviewing the legislation. When we come to the Hungarian Constitutional Court, the decision expressly states that Article P obliges the state or the legislator to take scientific consensus into consideration alongside the precautionary principle, the principle of prevention, which can only be operationalized if we use science to underpin it. And again, incidentally, science is taken as a yardstick of review. And last but not least, let us come to two important figures in the different decisions: the duty of care in the Bundesverfassungsgerichts Entscheidung. Article 20A, according to the court, imposes a special duty of care on the legislator to take into account those serious and irreversible consequences that legislation can cause, in particular for future generations. And the same idea finds a kind of expression in the public trust doctrine, which goes back already to the Forest Act decision of the Constitutional Court. And the public trust doctrine, as has already been explained today, means that the Hungarian state holds in trust the natural environment for future generations because they are the beneficiaries of this. And we can use as present generation this environment, but not to the detriment of future generations' interests. Finally, obviously, both decisions rely on international law. As you can see, there's a huge parallel with the Paris Agreement and EU law being invoked, and also in the case of the Hungarian Constitutional Court, also the Klimazenioren case. And now I come to my conclusion so that we can all go and have lunch. What is clear from these two decisions, and especially the Hungarian decision following the Klimabeschluss, is this palpable tendency of judicial learning, and of course the petitioners learning, taking each other's decisions as inspiration, which is a wonderful way to create an alliance of courts in this fight against climate change. And it also shows that courts are willing to lead the way where political will breaks down. So courts are going to step in and help push the legislator to be more ambitious. And thankfully, we can glean from both of the decisions that at last future generations receive more and more attention, and this can help in preserve our environment for the next generations. And thank you for your kind attention. Let's have lunch.
Ladies and gentlemen, it's time for the lunch break, and we have got 45 minutes to enjoy the lunch. So we would like to continue at 1:45. And if you have not visited the balcony so far, and if you are interested in a beautiful view, don't miss the opportunity to go out for some refreshing good air and great views. Thank you.
A nyilakat esetleg, de hogyha
A nyilakat?
igen, ha szeretné, akkor ezt a...
Már hogy melyiket?
Ezeket.
Jobb oldalt.
Ezt meg a bal oldalit. Vagy hogyha szeretné, használhatja a pointert is.
Jó, hát tegye le azt.
Itt majd be kell esetleg kapcsolni, hogyha itt
Ja,
el kell.
jó, de akkor ez.
De az biztos, hogy működni fog.
Oh, great. Amazing.
Everybody discovered the balcony.
No, no.
We would meet at the lobby of your hotel at 7, between 7:20 and 7:30.
Okay, I will come down. I will be there.
Then I ask Shani to buy your ticket.
Okay. Video distance.
Yeah, it's so beautiful there. Hello. Brilliant. Brilliant. Thank you. Yeah, likewise. It's been so interesting today. We're supposed to have started, so I imagine any minute now, but again, probably have a few minutes to just get comfortable. constant bubbles and just go chill there.
És akkor gyorsan mondta, hogy úristen, van még 5 percem, mert lehívja az igazgatót.
Lead us off. Our leader today? No? What?
They just put me moving of the topic is more general. It's so broad.
Kicsit először, tehát hogy addig nem
Everybody just leading up to melody is the big finish.
The main thing is that everyone is quite great. Otherwise, we'll just want to see, especially if they have yeah, no, I mean, I was in 2 minds about it, but yeah, it's not risky.
To stimulate thinking, otherwise I am not.
So, ladies and gentlemen, we will continue the conference with the afternoon panel within 1 or 2 minutes. Thank you so much.
Ottavio, I'm very much waiting your...
Yeah. You'll see myself.
Exactly. Like, are you in the right?
Megpróbálni.
Hogy
mielőtt
induljon
a
el?
tartalmi dolgokat.
To move the slides, what do I have to do? I just click, okay, now I can go back, let's do it like that. Okay, now.
Or maybe with the arrows.
Ah, with the arrows, fantastic, this is even easier. Show the thing here. All right.
Yeah. Okay, so ladies and gentlemen, thank you very much for being here in the afternoon and for joining us for this conference. This is our last and final panel for our 2-day conference, and now we are trying to introduce some kind of best practices from all around the world. Our first speaker is Professor Ottavio Quirico, who is a professor of international law at the University of New England, Australia, and the Australian National University Centre for European Studies at Perugia University for Foreigners. Professor Quirico won several awards during his career, including a Marie Curie Fellow at the University Panthéon-Assas, Max Weber Fellow at the European University Institute, Visiting Fellow at the Lauterbach Center for International Law at Cambridge University. He has lectured in universities worldwide, practiced in Europe, and acted as a consultant to the United Nations, among others. And his research covers international relations with focus on economic issues. Professor Quirico, the floor is yours.
Thank you. Thank you very much. Marcel, so good to see you. That's the priority coming here. Then there is the conference, which is outstanding. So thanks to you and all the organizers for involving me. I will just develop some tentative thoughts on the obligation to mitigate greenhouse gas emissions and adapt to climate change. First, some numbers, some data. In about 170 years, we have achieved the 1.5 temperature increase. According to the World Meteorological Organization, 2024 was the hottest year on record, with an increase of 1.55 above pre-industrial levels. To provide an idea of what this means, think that in the previous 80,000 centuries, well, a change of the microphone. No? What do I have to do? Close to the microphone. Don't grab it. All right. Okay. I like to grab the microphone. I will refrain. So, in the previous 80,000 years, we had changes of 3 to 5 degrees over thousands of years. Okay. Now, what do we need to do? Science tells us that we need to reduce greenhouse gas emissions by 7 to 13.5% yearly, on a yearly basis, up to 2030, to stay within the new limit, which is, of course, 2 degrees. And instead, temperatures are rising at a rate of 0.64% per year. Okay, so these flowcharts show, on the one hand, the increase, the anomalous increase, and where we're going and where we should go with the current policies. So essentially, we are on track to achieving temperatures that existed, that were registered in the Paleocene, Ecocene, when apparently alligators lived up in the Arctic. There's a nice book written by Peter Dorman, published with CUP in 2022 on the topic. So what can the law do? I think the law does not have the solution per se. The law can foster technological innovation. Okay, we have seen, we have the UNFCCC, the Paris Agreement, and the answer entails on the one hand mitigation, that is limitation of greenhouse gas emissions, and improvement of carbon sinks, such as forests, and on the other hand, adaptation, that is adjustment to the consequences of climate change. And here, I will focus on both mitigation and adaptation, trying to compose the puzzle and compare, based in particular on the role of the courts, which play a key role. This has been said, this was said yesterday, in interpreting the regulatory instruments. So the courts play a kind of role as lawmakers in a Kelsenian sense. So mitigation, so basically making the climate sustainable. So in this sense, I think we can speak of a right to a sustainable climate. Okay, is it hard law? Is it soft law? Who are the right holders? Who are the duty bearers? Is it an obligation of conduct? Is it an obligation of result? Let us see some cases. Starting with the common law. We have seen some cases already. I will focus possibly on other cases. We started with Legari and Pakistan, where we had a positive outcome, that is an obligation on the state to reduce greenhouse gas emissions based on the right to a healthy environment. But then we have a negative approach, in my view, a negative trend. In Juliana and the United States, I will not go into the detail, commenced in 2015, ended in 2025. The outcome is eventually negative. It was positive in the first instance, negative on appeal, then it went through a set of recourses in 2025, Supreme Court. So the constitutional right to a sustainable climate, not environment, there it was sustainable climate, was denied eventually. Similar approach, but with respect to corporations, not the state, in Kivalina and ExxonMobil. Similar trend in Canada. Here I have the Law Imgin case, which is a constitutional case, and yesterday we saw in New Zealand the trend is not particularly positive. At the regional level, we have the Inter-American Commission on Human Rights, the Inuit case. Well, it was not even addressed, I think. I mean, had I prepared that petition and had received that answer, I would not be particularly happy. Here I wonder, but en passant, let's say if a negative decision is tantamount to an implicit recognition that the obligation to cut greenhouse gas emissions is an obligation of means. That is, we do not decide as courts on precise reductions, it is up to the legislator. So basically do what you can, okay? But en passant, okay? Civil law, here the trend in my view is slightly more positive because we have Urgenda, where on top of everything, the duty to cut greenhouse gas emissions was clearly outlined as a duty of result. Same in, well, we have seen other cases, Belgium, Brazil, there are differences, of course, but the trend is positive in some jurisdictions, including Brazil and some cases in South America, which are particularly interesting. Same vis-à-vis Shell as a corporation, but whereas in the first instance, the duty was clearly outlined as a duty of result on appeal. It is no longer, there is no specific result identified. There is an interesting constitutional Russian case where plaintiffs claim that Russia should reduce fourth major emitter of greenhouse gases in the world should reduce by 31% emissions by 2030, reject. On the spot, basically. The negative trend continues. I think there's a very interesting case in Norway, Greenpeace and Ministry of Petroleum. There was licensing by the Norwegian government for deep seabed mining. Action in court based on Paris Agreement in particular, scope 1, 2, 3 emissions, rejected first instance appeal and High Court, Supreme Court, okay. Recourse to the European Court of Human Rights, okay. And then we have a negative trend also in Finland, Finnish Association for Nature Conservation and Finland, decided in 2024. Now, regional level, what do we have? European Court, first of all, European Court of Justice, fundamentally on procedural ground, we have a negative approach because in particular in Armando Carvalho, action was rejected, no individual damage, no action. European Court of Human Rights, let us consider that Russia is no longer a party, it withdrew, but for jurisdictions such as Norway, Finland, and of course other jurisdictions, there is competence. Well, with some limits that in terms of standing in particular were pointed out yesterday, where we have Prima Signorinen, where basically the court stated that Switzerland has to improve its mitigation and adaptation policies. But there we have the problem of enforcement, which in scholarly literature is a little bit overlooked to my mind. That is we have the judgment when we have it, and here the trend is not particularly positive, can we enforce it? Seems to me that Switzerland is reluctant to implement the decision in terms of both mitigation and adaptation, and the situation is in the hands of the Council of Ministers of the Council of Europe. So besides this divide between civil law and common law jurisdictions, let me point out that when we take into account jurisdictions, Arctic jurisdictions, the trend is absolutely negative because we have seen the US, Juliana, Canada, Loingin, Norway, Greenpeace, Finland, Russia. Okay, well, I have no cases from Denmark, but from these jurisdictions, and we know that the Arctic is particularly affected with temperatures rising 3 times more than the global average, apparently. Probably this is an interesting map. This is the distribution of resources. 13% of global undiscovered oil and gas, oil in the Arctic, 30% of undiscovered natural gas, and also critical minerals, which are nonetheless also useful to the green transition. Here we have navigation routes that are much faster than the Suez and Panama Canal. And here we have shrinking ice. You can clearly see the extension in 2014 darker and light kind of gray color, 2024, all right. And here there are the claims to extended continental shelves. The UNCLOS Commission recognized that basically Russia has sovereignty over more than half, basically, roughly, of the continental shelf. So what does this tell us? I mean, here we have clearly the trade-off between sustainability and economic development. What is the priority here? If we look at claims to extended continental shelves and Arctic licenses, Norwegian licenses for seabed mining, the priority seems to be economic development. Then if you have a look at also the Arctic policies, which have been released recently by different states, they are quite ambiguous. But well, then the jurisdictions are not correcting this trend. So I think here we can exclude market-based solutions, apparently, prima facie, let's say, to the problem, to the climate problem. In terms of mitigation, let us now come to adaptation. So that's what I mean, probably better reflected or embedded in the idea of a right to climate sustainability. So not the climate that is sustainable per se, but the fact, indicating the fact that we have to adjust to a changing climate. Again, what type of obligations do we have? Not much scholarly work. A couple of scholars from medicine and philosophy have worked on the idea of a right, human right to adaptation. There is more evidence of practice because there is the work of the special rapporteur to the Human Rights Council, inter alia the Safe Climate Report, that clearly frames adaptation within the context of the obligation to respect, protect, and fulfill human rights. Among the cases, we have Klimasenjorinen, which we have considered, and then we have Billy and Australia. This action, this petition, was for both mitigation and adaptation. The Council disregarded mitigation and instead decided, recommended that Australia implement adequate adaptation measures, creating adequate seawalls to protect indigenous peoples, Torres Strait Islanders, burial sites from inundation, and the decision, based inter alia on the right to culture, leads to a sanction in terms of reparation and compensation. Okay, so in conclusion, what about mitigation? What do we have? The case law is fragmented. In my view, we can say that it is more negative than positive, particularly in the common law, absolutely negative in Arctic jurisdictions. When it is positive, the duty to curb greenhouse gas emissions is mostly framed as an obligation of result. Adaptation is framed as a secondary consequence of mitigation. So if mitigation is not sufficient, we need to adapt. It is emerging as a human rights issue and possibly also as a human rights per se. Not much case law, but mostly positive, Klimasenjorinen and Billy, with clear implications in terms of sanctions here. No, it is framed in the context of loss and damage adaptation. And entails what? Restitution, so implement adequate adaptation measures and compensation. Then I don't know if there are enforcement problems at the level of the decision, as concerns the decision in Billy and Australia. With regard to mitigation, certainly we have some problems. And this is the conclusion framed according to a kind of Kelsenian scheme, computational. So primary role, mitigation, breach, adjudication, sanction, B, 1, 2. The sanction, in my view, for the obligation to curb greenhouse gas emission is non-repetition. You are not curb adequately. Okay, mostly shaped as an obligation of result. Another consequence, possibly an additional sanction, is adaptation. Breach, possibly again adjudication, sanction, again in this case it is no longer non-repetition, but it is reparation. Restitution integrum and compensation. I think, well, this schematizes a little bit, but is this enough to contain temperature increase within now 2 degrees Celsius? Thank you.
Professor Quirico, thank you so much for this presentation. Our next speaker is from the Pázmány Péter Catholic University, Laura Gyenei, who is Vice Head of Department of European Law at the Pázmány Catholic University. Her main area of research is the rights and duties of union citizens, if I'm right, and among other things, Laura is the Director General of the Budapest-based Institute for Protection of Minority Rights, dealing with national minority issues. And if I'm right, during our conference, only Professor Markus Gehring analyzed in detail the European law aspects of climate change. And now Laura will continue this topic. Laura.
Ladies and gentlemen, dear colleagues. Anyone who deals with European Union law, as I do, will often find that the European Union is taking over more and more fields of competence that are formerly within shared competencies between the member states and the European Union. The commonly used instrument for this kind of activism is the principle of preemption, where member states lose their ability to legislate in areas where the European Union has already done so. Recent case law of the European Court of Justice also shows that the requirements of EU law must apply even in areas of exclusive national competence. Just a few weeks ago, in Malta's Golden Passport citizenship case, the court ruled that member states do not have unlimited freedom to grant citizenship and must also consider the requirements of European Union law. What about the EU's climate laws? They are both progressive and conservative at the same time. In my presentation, I will introduce these two elements of European Union law. In substance, EU environmental law contains strong and ambitious provisions that seriously affect the daily lives of member states, their citizens, and businesses. But when it comes to important EU climate law co-decisions, the list is very, very short. Before all, let me say a few words about the framework of substantive law. Environmental legislation at the EU level began in 1973 with the adoption of the first Environmental Action Programme, which was in line with the international trends at the time. Just a year before, the United Nations Conference on the Environment in Stockholm was held, which marked the beginning of international environmental law. This action program is important for two reasons. First, This document lays down the main environmental law principles that are still important for EU environmental law. For example, it talks about the precautionary principle, a concept in international law that has been largely overlooked in international treaties and court decisions. We are all familiar with this from the Gacsikovo-Nagymaros judgment. It is fair to state then that precautionary principle is very important in European Union law. Second, this environmental action program was adopted at a time when the European Union primary law did not yet grant the European Union any regulatory powers in the field of environmental law. It was only with the Single European Act that the EU gained competence in environmental law, which was detailed first in the Maastricht Treaty and then in the Amsterdam Treaty. While I won't go into the rules in detail here, I will highlight 4 key principles that are still at the heart of EU environmental law today. Environmental law was the first area in which the EU introduced the well-known principle of subsidiarity. Environmental law typically involves setting general principles at a higher level, while specific detailed implementation rules can be set at a lower level. Take the example of greenhouse gas emission obligations. The exact reduction target for each member state can be set at the EU level, but they are free to decide how to implement this general obligation. This model is similar to, to how the EU legislature uses directives to make EU law work in practice. EU law sets the objective, and member states choose the means to achieve it. Secondly, the so-called stricter national standards clause is of great importance in EU environmental law. This clause states that EU law only requires a minimum level of regulation, and individual member states can set stricter standards than that. This model is a common form of human rights protection regulation. For example, as the level of legal protection in a state's legal system increases, the more attractive the business environment becomes for foreign investors. But in the field of environmental protection, this model is up for debate. Stricter environmental rules can place companies at a disadvantage. This is why most member states don't really want to adopt stricter rules. This is evident in the case of greenhouse gas emission reductions. The vast majority of member states are reluctant to exceed the requirements of EU law. When the EU was established, its objectives included achieving balanced and sustainable economic and social development. Protecting the environment became an explicit means of achieving this. However, the legal nature of the EU's objective is rather specific. Only one objective that has taken a life its own. In recent years, the rule of law, while the nature of the others is more akin to soft law. Finally, key innovation of the Amsterdam Treaty was that it extended the requirement for a high level of environmental protection to cover the entire body of EU legislation, not just environmental law. Last but not least, the right to a healthy environment is enshrined in the Charter of Fundamental Rights, laying down the foundations for human rights legislation to protect the environment. What follows from the above? Without going into the details of the EU's environmental law, we can see a legal system equipped to ensure the highest level of environmental protection. In the field of climate protection, the European Green Deal is a perfect example. It guarantees that Europe will be a climate neutral entity by 2050, with a budget of around 600 billion euros allocated to achieving this. In its recent climate decision, the Hungarian Constitutional Court also pointed out that the principle of common but differentiated responsibilities applies to greenhouse gas emissions. In economic terms, this principle, first articulated by Garrett Hardin, operates like the tragedy of the common in the fight against climate change. Hardin illustrates the tragedy of the commons by the example of a field that can support 10 cows, each producing 10 liters of milk, with a baseline of 10 farmers, each having 1 cow. However, once a farmer puts an extra cow in the field, the cows have less grass and their yield drops to 9 liters. Over time, the other farmers will do the same. Soon, the 2 cows together no longer gives as much milk as 1 cow did before, but if one of the farmers were to sell one of the cows, his position would be even worse. The European Union's very ambitious approach to climate change regulation could have provided a model for countries around the world. But in practice, the beneficiaries of the EU's commitment have been those countries that have not changed their own climate policies. I will now turn to the issue of procedural law. If EU environmental and climate law is so ambitious, why can we only cite examples from recent case law of the Strasbourg Court, particularly the Klima Seniorinnen case, and national courts? Why can't we talk about a truly big EU-level climate case? This is due to the jurisdiction of the European Court of Justice. Current procedural law does not support individuals submitting claims to the European Court of Justice. 3 types of procedures could be considered as the basis for an EU-wide climate lawsuit, but none of them are suitable. The first solution is to focus on the so-called infringement procedure, especially those launched by the Commission. This is because the number of cases brought by member states against each other is quite small, only 15 cases in 60 years. And of these, only one, the Czech Republic versus Poland, has an environmental dimension. The inefficiency of the infringement procedures in these areas can be traced back to at least 2 reasons. Firstly, when the EU legislator introduces a regulation, the member state no longer has any legislative scope, making it difficult to interpret the possibility of infringement. Secondly, if member states do not tighten their legislation, this is not considered an infringement, and the obligation to take specific measures can rarely be derived from EU law. The second option is to initiate a preliminary ruling procedure. These cases are resolved by national courts, and the Luxembourg court merely assists with this process. It is therefore difficult to consider them real EU cases. The third option is an action for annulment of EU legislation or an action for failure to act. This is worth discussing at some length because this could be the procedural element of a real climate lawsuit under EU law. These Luxembourg court procedures are classical procedures similar to the review procedures of national constitutional courts. Although most EU member states now have a leading climate case, there is not yet one at the EU level. This is not entirely clear, given that the court usually takes a progressive approach to all matters relating to the development of EU law. A striking example of this is the Zambrano case law in the field of EU citizenship law. The explanation lies in the fact that although the court takes a progressive approach to the merits of a case, it is very conservative on procedural issues, such as the question of eligibility. A good example of this is the EU biomass case, where the applicants challenged EU's classification of forest biomass as a renewable energy source. They argued that burning forest biomass produces higher levels of carbon dioxide than burning fossil fuels. In this case, the applicants argued that they are directly and individually concerned by the relevant EU legislation, the Renewable Energy Directive, so that they fulfill the criteria of the so-called Plowman test. The case was decided by the General Court, which confirmed, even on the assumption that the contested directive does infringe the applicants' fundamental rights, the applicants have not demonstrated that the directive is such as to distinguish them individually from all other natural or legal persons in the same way as the person to whom the act is addressed. Advocate General Jacobs described this phenomenon in the Union de Pequeños Agricultores case. According to the court's case law, the more serious the infringement, the harder it is to meet the Plowman test. This is because the more people affected by the infringement, the harder it is for them to distinguish themselves from everyone else, which is a requirement for submitting a claim to the European Court. So, what can be done? While the Plowman test seems to be a sacred cow that the European Court of Justice doesn't want to touch, it is possible to find an alternative legal solution in climate matters, given that the EU is a party to the Aarhus Convention. In 2006, the European Union adopted the Aarhus Regulation to ensure access to justice. Article 10 of the regulation provides for an internal review mechanism that allows environmental associations to request review of decisions made by EU institutions. If they disagree with the outcome, they can take the case to court. Following the Aarhus Compliance Committee's finding in 2017 that the EU was in breach of the Convention's access to justice requirements, the EU expanded the scope of decisions to which the internal review mechanism can apply by amending the regulation in 2021. Based on this, practically any administrative act can be challenged in the General Court, regardless whether it complies with the Plowman test. However, this solution has one drawback. It doesn't apply to legislative acts. The General Court is currently hearing a case concerning the inadequacy of the Commission's decision to reduce greenhouse gas emissions, and it remains to be seen how the General Court will decide this case. If I'm correct, Mrs. Erika Fiala-Butora, the lawyer of the applicant, is also here with us today. So, what are the conclusions? First, EU law provides strong substantive tools but weak procedural mechanisms. Second, limited access to justice undermines climate ambitions. And finally, reforms mark progress, but significant legal hurdles to climate litigation remain. Thank you for your kind attention.
Ladies and gentlemen, dear colleagues, thank you, Laura, for this excellent presentation. And now our next two speakers will speak about the United States position, or maybe some states of the United States position within, in connection with climate change and in contribution to the protection of the environment. First, Professor Aaron Schwabach, and then Professor Richard Walsgrove. Professor, to be honest, I spent several months in San Diego years ago, and Professor Schwabach was one of my host professors, so for me it's a special privilege to introduce her as our next speaker. And Professor Schwabach is a professor of law at the California Western School of Law in San Diego. His main area of research covers intellectual property and environmental law, and maybe the most exciting part of his expertise is that he's an expert of the law of the Wizarding World of Harry Potter. And Professor Schwabach has delivered several lectures in China, in France, and in Hungary. And among other things, Professor Schwabach is one of the editorial board members of the Hungarian Yearbook of International Law and European Law. So, Professor Schwabach, the floor is yours.
I'm terrible at keeping track of time, so I'm setting a timer for myself here to make sure I don't go too far over. Oh, this is the clicker. Okay. Okay, so one of the disadvantages of going toward the end of a conference like this is there's a danger that everything that you have to say will already have been said. And quite a lot of what I had to say has in fact been addressed by others of you, probably better than I could have done it. So I'm going to probably fast forward through a couple of my slides here. But the advantage of going toward the end is that I get to hear what everyone else has to say, and I get informed by it, and I learn from it, and it changes how I think about things. And in particular, I started out with this slide here. This was originally the last slide in my presentation, and the only one with a picture in it. This is a picture I took about a week ago, just before leaving the US, about a mile from my house. I walked over here and was walking along and took this picture in the morning. This is the California coast. And I was inspired by something that Professor and Justice Sabo had to say earlier today, which is that a landscape is part of cultural heritage. It's part of our identity, part of what we define ourselves as. I'm standing here under a picture of Balaton, and over here I can see Visegrad overlooking the Danube at the site of Nagymaros, which of course all of us know very well for its landmark importance in international environmental law. And you mentioned, Professor Sabo, the puszta as part of Hungary's identity. And as soon as you said that, I thought back to 10 years ago when I was visiting University of Debrecen at the invitation of Dr. Semesi. My family and I went out to Hortobágya National Park, to the Nonius stud, and we borrowed some horses. After assuring the manager of the stud that we were in fact capable of riding the horses, he let us go out and gallop across the puszta. And although I'm a visitor in this country, I still felt that was something very special, and I felt somehow closer to the country because of it. So looking at this picture, you see, oh, there's some coastline and some plants there. I can think of the exact smell of the sage as you brush through it on foot or on horseback, the sound of the rattlesnake as you get a little bit too close, of what it's like to walk through there, climbing down to the beach, carrying a surfboard. This is part of the identity of California. And like the puszta, it's under threat. What you see here, this land, is sand. It's compressed sand, very loose sandstone. It was a submarine terrace that was uplifted about 10 million years ago and heavily contoured by erosion. And as the climate changes, the rainfall in San Diego increases and this sand erodes much more rapidly. The cliffs are visibly crumbling in a lot of places. The species here of indigenous plants are, of course, under threat because of change in weather patterns and so forth. And that brings me, I guess, by a roundabout way to California's climate law. You have to think, what's the constituency? Sorry, I'm getting too far from the microphone. What's the constituency for pollution? Nobody. Nobody wants to live in a polluted environment. Somehow it has become politicized and identified, at least in the United States, I can't speak for other countries, as an issue of the left. But that doesn't mean that all those people on the other side of the political spectrum who may disagree about things like gender identity or the nature of the family or something, it doesn't mean they want to live in a polluted environment. It doesn't mean they want their homeland destroyed by climate change. What I think this reflects is a failure of democracy. And we have become susceptible to capture by a few strongly interested groups. We can't even say that there's really a tension between environmental protection and the environment. The environment is obviously worse off if California's coast here is destroyed. We will lose huge amounts of revenue in our state's biggest industry, agriculture, our second biggest industry, tourism. We will lose probably close to $1 trillion just in coastal real estate value alone. It will be very, very bad for our economy and bad for most industries, but a handful of industries have been able to shape federal policy and federal law on this subject, mostly fossil fuel companies, automobile manufacturers, and the like. As I said, this is a failure of democracy and a deep problem that I don't have any solution to offer to. If I did, gosh, I'd have a Nobel Prize. But for a while, we did have a partial solution. The United States is a very large country. It occupies about a third of the North American continent, maybe a little bit more. And it has very, very different regions. The bulk of the population and political power for a long time has been on the East Coast. The entire West Coast, from Alaska down to Tierra del Fuego, of both North and South America, is a small area between the ocean and a very high mountain range. The Rockies in the United States, the whole thing together is called the Cordillera, running down North and South America. And winds blow primarily from the west. They come in from the Pacific Ocean, but on the other side of the mountain are deserts, and hot air from there often comes in the other direction. The cold air comes in here, the hot air comes in here, forms I'm not a meteorologist here, but an inversion layer forms a barrier that prevents pollutants from dispersing. Essentially, a lid is put on that area between the mountains and the sea. This means that the west coast of North and South America is especially susceptible to air pollution. And the Los Angeles Basin even more so, because it's surrounded by mountains not only to the east, but also to the north and a little bit to the south. So back when the Clean Air was passed in the first place, an exception was created for California to make its own air quality standards. And this was wonderful, because air quality standards that would be fine for Washington, D.C. and New York City would create unacceptably high levels of pollution in Los Angeles. The immediate effect of this was that 12 other states, and I wrote them down here somewhere because I can't remember them all off the top of my head. They're the other West Coast states plus some scattered states in other parts of the country. So Colorado, Connecticut, Delaware, Maine, Maryland. Sorry, most of these names I know are not that helpful. Minnesota, Nevada, New Jersey, New Mexico, New York, Oregon, Washington, and the other Washington, Washington State and Washington, D.C. So the West Coast states right there along the coast, plus inland Nevada and Colorado, just inland from them, and then most of the Northeast. And oddly, New Mexico is in there too. So these states have all followed the California standards, and what this has meant is that car manufacturers effectively had to follow the California standards. If you wanted to sell cars in the United States, California is 1 out of 9 people in America is a Californian. It's 1/9 of the population. It's a prosperous state with a dozen other states signing on board as well. You wouldn't be able to sell cars in the US market without meeting the California standards. Obviously, car companies were not delighted with this. But nonetheless, the effect was all cars sold anywhere in the US met the California standards. Here it is, California. During the first Trump administration, President Trump revoked the waiver for California, California's exception, allowing it to set its own air quality standards. Nothing happened. There were a lot of lawsuits that effectively blocked implementation of this revocation. And before they could be resolved, Trump was no longer president, and Biden, on his first day in office, revoked the revocation. And so things were fine for 4 years, and we got complacent. And Congress did nothing to cement this in place. The new Trump administration has directed the Attorney General to identify state and local acts that may be unconstitutional or preempted by federal law, singling out not California's automotive air quality standards, but its cap and trade program. So California has a program which sets limits for carbon emissions. And just like any cap and trade program, above that limit, you can purchase carbon credits. Carbon credits can be exchanged, they can be traded, and so forth. But I want to detour for a moment to take a look at the wording of the executive order. And I apologize, because this is surely too small to read back there. So I'm going to read it out. I can't actually do the voice of President Trump, but imagine, if you will, that I am. Just the tone of this is very unusual. Executive orders are usually bone dry, dull. This one shows a lot of peevishness. Many states have enacted or are in the process of enacting burdensome and ideologically motivated climate change or energy policies. Notice that climate change is in quotation marks, as if it's not a real thing, that threaten American energy dominance and our economic and national security. New York, for example, enacted there it is again, climate change, extortion law. Extortion, that's a crime. Extortion law that seeks to retroactively impose billions in fines. Erroneously labeled compensatory payments, so he's recharacterizing the New York law, on traditional energy producers for their purported past contributions to greenhouse gas emissions. This is pure climate change denialism here. Not only in New York, but also anywhere in the United States and the world. Vermont similarly extorts energy producers for alleged past contributions to greenhouse gas emissions anywhere in the United States or the globe. Other states have taken different approaches in an effort to dictate national energy policy. California, for example, punishes carbon use. I'm not even going there. By adopting impossible caps on the amount of carbon businesses may use, all but forcing business to pay large sums to trade. Again, why the quotes? Trading is what actually happens. Carbon credits to meet California's radical requirements. Some states delay review of permit applications to produce energy, creating de facto barriers to entry in the energy market. States have also sued energy companies for supposed climate change and, quote again, harm under nuisance or other tort regimes that could result in crippling damages. I'm going to briefly say something about that last sentence and then go to the whole thing. Tort and nuisance are state law matters. They're not federal law matters, so they're entirely inappropriate topics for a federal executive order. The air quality standards admittedly are a federal law matter, so it at least is within the president's scope of authority to address it. I have never read an executive order with this much anger in it from any other administration. It's quite startling, but that's sort of typical. Yes. Right. Yeah, don't use the all caps this time. So let's go way back in time here to before January 2017 and the beginning of the first Trump administration. In addition to its own, to its ability to set its own air quality standards, California had enacted or adopted a number of climate control, climate protection measures, starting with the Global Warming Solutions Act, signed into law by Governor Schwarzenegger. And I apologize for not including a picture here because I know that's sort of traditional whenever we mention our former governor. But requiring California to reduce GHG emissions to 1990 levels by 2020. This was actually following up on something he had done the previous year, Schwarzenegger had signed an executive order doing the same thing, but the governor of California doesn't have authority to actually give any teeth to that. When the governor passes an executive order like that or promulgates an executive order like that, it's hortatory, it's not mandatory. The act, which came the following year, made it mandatory. 4 years later, in implementation of all this, the cap and trade carbon credit program we have now. Whoops, I am over my time, I'm sorry. So I'm going to quickly zoom through as fast as I can the last couple of things. 2010, a cap and trade carbon program was established. In 2013, this program was linked with a similar program in Quebec, creating a single carbon market in these two jurisdictions. And this now covers about 85% of California GHG emissions. So there they are, California and Quebec, as you can tell, on opposite sides of the continent. This is, we have been working on trying to get the other West Coast states and some of the East Coast states that are part of the Regional Greenhouse Gas Initiative to join in the common market, but it turns out setting up a common market for exchange of anything really, especially carbon credits, is very, very complicated. So although the intentions are good, the results are not there yet. Very quickly, 2016, an additional California Global Warming Solutions Act was signed into law by Governor Jerry Brown. I usually, at this point, would include a photo of Jerry Brown and Linda Ronstadt because they used to date. The new law expanded the 2006 targets, requiring a 40% reduction by 1990 levels, below 1990 levels by 2030. And we have a set of executive orders that have implemented this requirement, which I'm going to skim over because I'm so far over time. But as you can see, actually, maybe you can't see. So carbon neutrality by 2045, net negative emissions thereafter, all new passenger cars and trucks, drayage trucks, and off-road vehicles to be zero emission in 10 years by 2035, 10 years from now, and heavy trucks to be zero emission by 2045, with the acknowledgement that for some trucks that won't be possible. I'm going to skip over the federal stuff because I believe my colleague will address some of it slightly, and because I think all of you are more aware of it than you are of this particular odd little thing in the state of California, and because I'm out of time. So I'm going to skip over the US's withdrawal, and quickly, I mentioned the Regional Greenhouse Gas Initiative. These are the states that are parties to it. As you can see, it's the Northeast minus California and North Carolina. California and North Carolina are, if we think of it in international terms, signatories but not parties. Not California, Pennsylvania and North Carolina. Pennsylvania's Supreme Court declared the initiative unconstitutional for Pennsylvania, not for anywhere else, of course. And North Carolina doesn't have the money. They have been unable to join for financial reasons, but still intentions are good. Unfortunately, 2 weeks ago, the president pushed through Congress legislation that takes away California's authority to set its own standards. So this is all, at this point, possibly just historical. It will be challenged in court, and we'll see what happens. It was revoked by a very odd means, using the Congressional Review Act instead of the more normal revocation process, which requires 60 votes, 60% vote, whereas the Review Act only requires a 51% vote. So some funny business happened, and we'll see how that comes out in court. I don't want to take too much more of my colleagues' time, so although I have more slides, I will leave it at that. Thank you, everyone, very much.
Thank you so much for this presentation and the perfect timing. And now we are still within the United States, exactly in Hawaii. Professor Richard Warsgrove, who is co-director of the Environmental Law Program at the University of Hawaii. His teaching and scholarship focuses on the clean energy transition and environmental law and business law issues. He also serves as the director of the school's Environmental Law Clinic, and he's co-author of the Pacific chapter of the 5th U.S. U.S. National Climate Assessment. Professor Wasgrove, the floor is yours.
Aloha mai kako. That's Hawaiian, and translated it means something like, to all of you, I express my gratitude, my affection, my thanks just for being here and for doing the work that you do. I have to start by expressing some extra aloha and extra gratitude to the folks that put this together. So Professor Szabo, thank you so much. It's been a remarkable experience to learn with you and from you has been fantastic. However, I also know it's not just Marcel. There are many other people who have worked on this. So thank you to Agnes, who's not here today. Dr. Smithy, thank you very much. My new friend David, who's doing the technology for us. So thank you, everybody. It's just been wonderful. I can tell from Aaron's beautifully understated way, I think he and I share a similar sentiment right now, which is we recognize the irony of showing up in a place like Hungary, which has just issued a historic climate decision, coming from the US, where we are in the midst of this radical and accelerating shift away from what was probably fairly described as climate apathy into active antagonism. So I want to describe for you some of that antagonism. The title on the slide here is US v. Hawaii. That's actually the title of a case that was filed a few weeks ago that I will end with today. Let's see if we can advance slides. The second thing you all have to know is that if you're in the back, it's the wrong place to be, because what I really want to do is show you a bunch of photos. It's a cheap way of getting your attention. This is my son. He's diving with actually a native reef fish here in Hawaii. We heard yesterday from Flora and Andras. I thought it was a wonderful way to start, to remind us that future generations aren't so future and the environment isn't so far away. So this picture, I use it all the time. This picture reminds me of that. And we'll create a background then for the more formal things and maybe slightly more boring things that we have to talk about. U.S. climate litigation is really of two worlds, and we got some of that from Aaron, right? There's federal climate issues, and that's where we're seeing some really dramatic roadblocks. But there's subnational litigation. There are 51 constitutions in the U.S. and 51 courts, highest courts that interpret those sorts of things. And so I want to talk to you about what's happening at the subnational level in 3 different streams. And I'm going to use Hawaii, my home, as an example. And you can tell, much like I'm very proud of my son Finn, I'm actually pretty proud of where Hawaii is on this as well. And I think will be ultimately part of this coalition, along with California and other places, that will be a backstop against some of what we've seen from the federal government. So let's start with the youth climate rights. This has gotten some attention over the past 2 days here. We've heard from Ottavio about the Giuliani decision, right, a constitutional youth rights case that was filed in federal courts and ultimately died not because there was a refusal of the courts to acknowledge a constitutional right to a livable climate, but under a really strained reading of the standing doctrine. Not that there wasn't a cognizable injury, but rather the court was uncomfortable with providing the remedy that the litigants sought in that case. And the remedy wasn't all that extreme. The remedy in the Giuliani case that the youth plaintiffs sought was just a plan for drawing down carbon emissions. That failed because the federal courts, and I'm going to say it with justices in the room, I say this with all respect, the federal courts they weren't brave enough. I won't say it. I'll let Marie-Claire say it. The federal courts weren't brave enough to order that sort of remedy. So what about the state courts? Are the state courts brave enough to order that remedy? I think they are, and I think Hawaii suggests that it's possible. We've heard about the Held case. This is the other youth climate rights case in the U.S. that's gotten some traction, and there indeed has been now a final decision in that case affirming the constitutional right to constitutional climate rights for youth plaintiffs. Did you know, before you arrived here today, that Hawaii actually resolved its youth climate case first, before the Held case? It was a group of teenagers who, with the help of our Children's Trust, the same public interest firm that represented the Held plaintiffs and the Giuliani plaintiffs, and plaintiffs all around the world, they filed a case asserting essentially two claims, two constitutional claims. The first is that the Hawaii Constitution guarantees a right to a clean, healthful environment, and that should include the right to a livable climate. The second claim was that the Hawaii Constitution includes a public trust concept, a public trust doctrine. In the background of those two constitutional principles in this case were two other statutes, two other laws that aren't constitutional. And all of these sound very familiar. We've heard about these, and I think in every jurisdiction that's been discussed so far. But there's a requirement, a mandate that Hawaii shift to renewable electricity generation, 100% renewable by 2045. That was a precursor to a policy target that says Hawaii should become a net negative jurisdiction in terms of carbon emissions by 2045. So that's the legal regime that we have to get our hands on here. Just four laws that I think you all recognize. The plaintiffs in this case did something interesting. This case is called Navahine. They could have made, I think, a very compelling argument in traditional ways well, sorry, I've skipped something. The reason I bring up that electricity mandate is that the plaintiffs in the Navahine case chose not to assert that they had a constitutional right to draw down emissions in the electricity sector. It was focused only on transportation. 65% of the state's emissions come from transportation, zero progress in that sector, and so this was the focus of this youth rights case. The remedy was, please come up with a plan for decarbonizing transportation in the state of Hawaii. So if you did that, you could show pictures like this, right? This is an inefficient and dirty transportation system. I think they could have made that case. They could have made the case that there are roads and other infrastructure that is falling apart because of things like sea level rise. Christina, this house is about 3 houses down from where you stayed when you were in Hawaii, so you might recognize this in its prior form. They could have argued that the state's economic engine, tourism, is being harmed by emissions, right? And it's actually tourism that pays for the transportation system. Those would have been all, I think, reasonable narratives to draw up. But they didn't. Their narrative was focused on something very different. It was focused on cultural rights, indigenous cultural rights. This is a headline taken from the newspaper. This is a place where the road is being washed away, so it's a transportation infrastructure problem. But as the road gets washed away, bones are falling out from underneath the road. And that's very important in Hawaiian indigenous culture. Traditionally, what you do with your bones when you pass away in Hawaii is you hide them. One person and one person only knows where they're placed. The bones contain your spirit, your mana, and when that person passes away, nobody forevermore can steal your mana. But if the bones are washing out from underneath the road, that is a cultural injury that is essentially cannot be remedied. It's been found. The mana has been released. And this was part of the description that was that was placed in the story of the Navahine case. They talked about cultural practices, pa'akai, the practice of making salt. There are 2 families on the island of Kauai, as I understand it, who have for centuries have practiced salt making. But now that the sea level is higher, it washes away the salt. That was described to me by one of the youth plaintiffs in the Navahine case. This is the breadbasket of Hawaii, where kalo, one of the food plants that was brought in with Polynesian navigators to Hawaii when the islands were first settled by humans. They brought with them kalo, they planted it, it fed something like 800,000 people 1,200 years ago. And rain bombs like this are affecting that sort of traditional agriculture. And this story of indigenous rights is the story that was painted by the Navahine plaintiffs. Why is that? Well, it's because the public trust doctrine that I showed you before, which I think reads just like the public trust doctrine in every constitution we've talked about for the past few days, has very, very different roots in Hawaii. It doesn't have roots in Western law and Roman law the way we've learned about. Actually, the public trust doctrine pre-existed Western contact in Hawaii, and it comes from the idea that the king, the chiefs, they existed in a reciprocal relationship with people. They were stewards of the land, stewards of resources, stewards of everything that mattered, but always for the benefit of the people. Sounds like the public trust doctrine to me, doesn't it? So that's where our public trust doctrine comes from, and the public trust doctrine has had a fair degree of success in enforcing indigenous rights in Hawaii. It makes sense then that the Navahine plaintiffs would have painted this story of sort of cultural injuries when they're trying to use the public trust doctrine to fix a broken transportation system. They succeeded, not because a court ordered them to, but because the state settled quickly. There were some initial attempts. They deposed children, which was, I thought, in poor taste. But relatively soon after the case was filed, a settlement was reached. Here are some of the plaintiffs with the governor and the director of the State Transportation Department celebrating that settlement. And guess what the state decided to do? To come up with a plan to decarbonize the transportation sector. We expect to see that plan sometime in the next month or 2. Doesn't seem like such a drastic remedy that a court couldn't order it. So in some ways, I think this is the state of Hawaii telling the federal courts, get with it. The Juliana remedy wasn't all that extreme. So that's stream number one, youth climate rights. That settlement was reached before the final decision in the held case. So I'm just gonna say Hawaii was first. I'm gonna keep saying that all day long. Why did the youth Navahine plaintiffs win, though? And the answer comes from a very different place. The answer comes from renewable energy litigation. This is a power plant on the Big Island of Hawaii called Huhonua. It was a colonial era plantation power plant. It used to burn fossil fuels. It shut down because we were retiring fossil fuel power generating facilities. And instead, this plant, the plan here was to have this plant burn trees. And some developers with questionable business sense invested $500 million with a B, $500 million in refurbishing this plant before they got regulatory approval. I've never heard of such a thing in my life. Nonetheless, they thought they'd be able to start up. When they didn't get the regulatory approval they wanted, lots of litigation ensued. I'm very proud to say that my first ever energy law student, about 2 years out of law school, took up this case on behalf of a local environmental group and challenged the challenge, appealed the appeal, essentially. And 4 trips to the Hawaii Supreme Court and back, we get a decision out of the Hawaii Supreme Court with 2 components to it. One was a concurrence by Justice Mike Wilson. I think several of you know Mike Wilson. He is retired now, so he will reveal that he is a climate advocate through and through. His decision reads like a decision from the European Court of Human Rights, right? It invokes the IPCC and a precautionary principle and lots of international legal principles. It's gotten lots of attention. But you know what? If you actually read the majority opinion, I think there's actually something to it that's remarkable. It was written by people who are not climate advocates, who don't know anything about the European Court of Human Rights. And here's what they said. The right to a clean and healthful environment encompasses the right to a life-sustaining climate system. That's what the Navahine plaintiffs asked for in their complaint. Several months later, this decision comes out, and this isn't actually what my student wanted from this decision. They just wanted the power plant not to be built. And yet the court carries forward this idea that the right to a clean and healthful environment is a climate right. The language just gets better and better the further you read. How far in am I? How much time do I? Oh, I've got time, great. The right to a life-sustaining climate system is not just affirmative, it's constantly evolving. This evokes some of what I think is in your decision, or the court's decision from this week, Marcel. Yesterday's good enough has become today's unacceptable. And then an interesting phenomenon. I described to you earlier the 2 statutes that today's talk was premised on, the idea of a mandate to decarbonize the electricity sector and a more aspirational, squishy policy target to decarbonize the entire economy. And here we have the Hawaii Supreme Court that describes that policy, that aspirational policy, as a mandate. It seems to me that that's obvious, and that's the way all of these European decisions are playing out. But this is actually a long way to go for a U.S. court, and of course backed up again with some rhetoric that I think is just as powerful as can be in this context. That the reason we have to do this is because the rights of future generations depend on it. That there is an irreversibility to climate change that we just have to acknowledge that is real. So that's the Huhonua decision, and it laid the groundwork for the Navahine decision. The way I think about this sometimes is that the questions about what we don't do are just as important about what we should do. We talk about implementation all the time, but it's the right implementation. And here's a role for the courts in finding the right implementation and turning away the $500 million or $500 million reasons to go forward with a bad plan. By the way, that tree burning power plant, it was renewable, so it would have satisfied the mandate. However, it also, over the next few decades, would have had emissions that were worse than coal. So it wasn't a decarbonization scheme by any stretch. The third stream, and one that I think actually springs from this jurisprudence, but not in very direct ways, is the idea of a climate tort. I've spoken with a few of you over the past few days about climate torts, and I know this is kind of an emerging idea. It's happening all over the place in the US. Here is a list of something like, I don't know, overall, I think it's 24 municipalities, local entities, that have sued fossil fuel companies under various tort theories for damages, adaptation damages, essentially, pay for the damage that was caused. States have also gotten onto the bandwagon here, so we have a group of 6 states that have filed similar claims, and Hawaii's been in that mix. The first was that the county of Honolulu, where I live, the county of Maui, sued all of the fossil fuel companies that operated in Hawaii a number of years ago under 3 tort theories: nuisance, failure to warn, and trespass. But because the federal courts have really firmly said that transboundary air pollution is a federal matter and can't be regulated by states, if we want to keep this within the realm of state tort law, as Aaron described, that's firmly a state doctrine in the US, this has been circumscribed a bit. And it's really now, it's about the tort of deceptive marketing, lying about the emissions for decades and decades and decades. And so, you know, nuisance doesn't feel to me like it's deceptive trade practices claim, but that's the way this is working out. There have been a number of attempts procedurally to stop this. Once again, I'm really proud of my students who drafted an amicus brief with several of the appellate courts, trying to keep this claim in state court, not allow it to go to the federal courts. It was actually taken to the federal courts, it came back to the state courts, taken to the federal courts again, came back to the state courts. About a year ago, there was an appeal by the fossil fuel companies to the US Supreme Court saying, look, this is transboundary air pollution, you must not let the states proceed. And the Supreme Court declined to take up the case. So it's back in state court in Hawaii, and the Honolulu case will be the first of all of these municipal tort cases in the US to go to trial. Probably. I mean, that's where we stand today. And then 3 weeks ago, the state of Hawaii gets in on the action and files its own claim. Nuisance, failure to warn, and trespass, premised on the idea of deceptive marketing of fossil fuels. But they've added 2 other claims, which I think are fascinating. One is a statutory consumer protection claim. Hawaii has very stringent consumer protection laws. This comes with treble damages and attorney's fees, which I think probably scares I don't know how many attorneys showed up at the Hawaii Supreme Court for this argument. I don't know, fossil fuel companies are paying for 100 lawyers at a time at $1,000 an hour. I think treble damages and attorney's fees are going to get somebody's attention in this claim. And then also, unique for a tort case, a public trust doctrine claim. And this is going to be fascinating to see how it plays out. My best guess is that this will be articulated as a claim for unjust enrichment. And the unjust enrichment is the product of deceiving state regulators. I think that's the way it's going to go, but as it stands now, we don't know. We just know public trust doctrine exists in Hawaii, it's in the complaint, we'll have to see how this plays out. So Aaron, what did the federal government decide to do knowing that this Hawaii versus fossil fuel claim was happening? Do you know?
Now I've been put on the spot.
No, you don't have to know. You saw the executive order where the Attorney General of the US has been ordered to go and find these lawsuits and squash them. Get a hold of this. The day before this complaint was filed, the US government filed a lawsuit, US versus Hawaii, asking for injunctive relief, prohibiting the state from filing its own lawsuit. I believe it's sanctionable. I will be fascinated to see where this turns out. I hope I've made the case to you that Hawaii is an interesting place for climate litigation. And if anybody wants any of these documents, I've been maintaining a Google Drive. I'm happy to give you the link to the Google Drive. Thanks very much for your attention. And even thanks to David, I have that in Hungarian on my slide.
Professor Wolfsgrove, thank you for this wonderful presentation. And last but not least, Professor Melanie Morcott from Cape Town, South Africa. Melanie just arrived tomorrow morning from Cape Town, and we are very, very grateful to her for this long journey. Professor Morcott is an associate professor of law in the Institute of Marine and Environmental Law at the University of Cape Town, and before joining academia, she worked as an attorney, and among other things, she authored the book of Transformative Environmental Constitutionalism, published by Brill publisher. Melanie, the floor is yours.
All right, well, it's a real honor to be the last speaker of today and to be with you all, having come a very long way.
And so I'm also going to time myself because I realize I'm standing between you and the end of the conference. What we've heard today tells us, as the young people would say, that we really are living in the stupid timeline. And it was with that in mind that I started thinking about transformative environmental constitutionalism about sort of almost 10 years ago now. And the reason I started thinking about that is I thought, what kind of constitutional tools does South Africa need to respond to the triple planetary crisis? And how best can our courts be responsive to that crisis, given that we have this incredible post-apartheid constitution? And so I did something similar to what's been spoken about today, where I went and looked for those legal hooks that can be used better and can be used just at all to promote better environmental activism and responses by the judiciary. And of course, there's so many motivations, but within our own context, we've had leaders like Desmond Tutu speak about how there will be no tomorrow if we don't break our addiction to fossil fuels. And so I wanted to get our courts and our lawyers more conscientized around that idea and to connect issues of social justice to environmental protection, given our particular history. And so, yeah, I began exploring what models of constitutionalism have this potential to be responsive to the triple planetary crisis, recognizing that not all constitutions are equal. And there are these diverging models, and we often speak about constitutionalism, issues of rule of law, issues of separation of powers, as if there is a single model, and it's often the European model, right? But in reality, there is a very rich tapestry of constitutionalism, including around environmental protection in different parts of the world. And so we start with the liberal model that treats people as individuals. The individual is the primary thing that's protected from state interference. And then in places like South Africa, we think about more post-liberal constitutions that are post-colonial, where they're coming out of an era of oppression and domination by the colonizer into a space of embracing diversity and wanting to transform from a racist and various other isms into an equal and more dignified society. And then we started to see constitutions, and sometimes concurrently, recognize environmental protections. And so we saw this phenomenon of the environment being a proper subject for protection in constitutional texts. And more recently, we see constitutions protect climate, and even more recently, we see constitutions protect rights of nature. So there's a whole tapestry. Where South Africa finds itself is in a space where we have this overarching social justice imperative in the preamble of our constitution. And we have various other tools like an incredible environmental right, rights to dignity, rights to life, rights of the child, rights to culture, 11 official languages recognized in our constitution, and all of that is to actively embrace the idea that we are no longer a colony. We are something new. We are returning to what we were, and we are building something new. And so with those ideas in mind, and finding those first principles of our Constitution, which is only just over 30 years old, I started to think about, well, how can we better use those tools to protect the environment? And another one of the tools that came to mind was the idea of Ubuntu. Ubuntu in South Africa and other parts of Africa is the value or the philosophy that I am because you are, and we are because the planet is. And this value permeates our entire constitution. In our first Constitutional Court judgment, the Makwanyane judgment that declared the death penalty unconstitutional, Ubuntu featured heavily in all of the judgments as a philosophy that meant moving forward in a transformative, egalitarian, and not vengeful way. And so we see these ideas permeating our constitutional ethos. But when I started this work, they hadn't yet been used to protect the environment, and the environmental right had only been used very little. And so this is where transformative environmentalism came in, how to bring this idea of social justice and environmental protection together and make the Constitution work to address the triple planetary crisis. So when I identified the need for this kind of theory, it was because we had a number of environmental judgments or dealing with environmental problems, but they did not really interpret and give those lovely judgments that we just heard about in the ways that they could, given the tools available. So we had courts really just overlooking the human faces that are suffering because of extractivism and multinational neocolonialism. And we had a heavy reliance on formal legal rules and procedural tools that sidelined and peripheralized environmental harms. Some of the judgments, you wouldn't even know they were about something like fracking, because that didn't come up. The issue was decided purely on a formal procedural issue. And then you had judgments that did engage with issues like the right to access to water, but they didn't connect the dots that water comes from the environment, and the environment needs to be protected so that access to water can be achieved. So we have these amazing tools not being used effectively. And then enter a transformative approach to environmental constitutionalism. And I'm putting this up very intentionally because if we look for the tools, as rigid and as impossible as the law seems to be able to change and address the problems we face, we will find them when we step out of our comfort zones. So I heard, this idea that judges have a restrictive role. Of course, there is a long-standing separation of powers doctrine. That doctrine has evolved over time, and it can evolve again. I've heard also issues about standing, how rigid it is, how difficult it is. And again, it can evolve if we're willing to be brave, as we've heard in other presentations. And so there are a few things that transformative environmental constitutionalism encourages judges to do, and we're starting to see some of these trends in the case law over the last few years. The first is really about, I don't want this to go off. It's really about joined up thinking. It's about putting a human face to environmental harms, and it's about saying that all of us, every single one of us, has not a single molecule in our body that doesn't come from the environment, that human systems and environmental systems are fundamentally intertwined, and that should be the starting point for every judgment on climate change. It doesn't have to be written into the text. It must be in our minds. And if it's not in our minds, we're ignoring scientific reality, that our bodies, our existence depends on a functioning and flourishing environment. So that starting point of a socio-ecological systems perspective is very important, and it's aligned with Ubuntu. I am because you are, we are because the planet is. There are many other philosophies that speak to this, including, I saw in Hungary's constitution, issues of community, of love, of coexistence. I thought those were really wonderful things in the preambular text, and those are some hooks. I saw they should be considered when interpreting legislation and the Constitution, and those are some hooks that could be used to advance this kind of perspective. The second thing, and I know that not every constitution allows for this, but where it does, we should advance it, is to embrace a substantive and value-laden interpretation of human rights. And I know that Mr. Trump would have very strong opinions about this and say it's ideological and it's radical, like both of those things are terrible. But when we recognize what are the values that are available to us in the text, and again, recognizing not all constitutions are equal, they were made in different times to respond to different social problems, But when we look for the values and we see how can they be responsive to the triple planetary crisis that we face, we can develop the content of rights accordingly. And then this was really done very beautifully in the case law that's been spoken about, is reliance on principles that are embedded in our law, such as the public trusteeship doctrine, and doing so not only from a Western European perspective, but also recognizing indigenous knowledge systems that had those doctrines long before they were formalized in written texts. And then finally is resisting, and this is something that was spoken about earlier, resisting compartmentalized thinking and resisting the binary thinking as well, the idea that norms are always competing with one another. Oftentimes, they can be mutually reinforcing of one another. So we cannot have rights to life without a healthy environment, and that's been well established in the other presentations today. And all of this joined up thinking, again, funnily enough, lines up with another quotation from Wangari Maathai, that the air we breathe, the water we drink, the food we eat, has to do with the environment. And when judges in this room and elsewhere in the world are adjudicating environmental disputes, this is the core existential issue that they are dealing with. Whether it's before them, it might be burning timber to make renewable energy, or it might be changing a transportation system, but the core issue is ultimately existential. And it's existential not only for the most vulnerable in society who will be first and hardest hit in places like where I come from, but for every one of us. And so this justice work that I'm speaking about, bringing up the justice issues into the foreground, whether it's in the text of the written judgment or in our minds, isn't about making things around identity. It's about acknowledging what's actually always been there, these complex real-life issues and the struggles of communities who are on the frontiers. So a couple of examples of case law in South Africa where we've seen some of these recognitions of socio-ecological systems thinking, joined-up thinking, and legal responses based on human rights approaches. I should just pause to mention that in South Africa, every aspect of law is constitutional. It's grounded in our Supreme Constitution. And every aspect of law, the court has the power to interpret and develop to bring it in line with the Constitution and its Bill of Rights. So it's overtly transformative in that sense. So there's no separate tort law that's distinct from human rights in South Africa. But in this case, we had a project case. We obviously brought those up in other contexts, so a decision about an urban development in a farming area on the edge of Cape Town, and in approving that urban development, a municipality and a provincial authority had not factored in water scarcity in a time of climate change. And the court said that that failure rendered their decision unlawful. And the reason the decision was unlawful is because the decision had to be made in a manner consistent with the environmental right. And a failure to apply the environmental right meant that the conduct of the state was unlawful. So we see how a simple administrative law challenge, bearing in mind the right to administrative justice is a human right in South Africa, was an environmental issue where the environmental right was enforced in a transformative way. Importantly, the court grounded its judgment in the systems of oppression that the community would experience if this development went ahead without considering water scarcity in a time of climate change. There's also the very famous Sustaining the Wild Coast case, or the Shell case as it's also known, where communities on the Eastern Cape's wild coast interdicted successfully and then reviewed successfully decisions authorizing Shell to engage in seismic surveys that would be devastating to marine life, but also to cultural practices and belief systems. This case won the day based on public trusteeship that is legislated into our Integrated Coastal Management Act, but also based on constitutionally protected human rights to culture, to participation in the form of administrative justice, and to environment. So there we see how the court embraced the mutually reinforcing nature of rights and really listened to and showed respect to the experiences, the lived realities of these communities. And I wanted to very explicitly put a human face to the people involved. These are the human faces not only when a South African court prevents Shell from doing a seismic survey off our wild coast. They're also the same human faces when a Dutch court says to Shell, you must reduce your emissions, and when another Dutch court says, you don't have to. And so in this case, you see a letter written by one of the women who lives in the area saying, I use the land for food and my family's graves are here. I will never allow mining in my area. And people in this community have been at the front lines of preventing fossil fuel development for the sake of the environment and their culture, which they see as being bound up. So this kind of bound up thinking, this joined up thinking, socio-ecological systems thinking that Notlem Butuma embraces is the kind of thinking I want to urge courts all over the world dealing with climate issues to adopt. What she said is this is not just a victory for the wild coast fighting to protect the ocean on which they depend, it's a victory against capitalist extraction and destruction of humanity's common future. It's a victory for the whole planet. Again, I don't expect you to put it in your judgments, but it can be at the back of your minds. Another more recent case is about preventing deadly air pollution. Again, what the court did really well here is connect the dots. It connected rights of the child, rights to life, right to the environment, and made a radical finding that the environmental right is an immediately realizable right. It's a right for the here and now. So to conclude, but given that it's been quite a challenging day, there's a lot of terrible things happening in our courts, in our governments, and our planet is burning. I wanted to share a very brief personal story that when my parents had me, they had me in the UK in exile because as an interracial couple, they could not have me and be married in South Africa, in their home country. And when that happened, they didn't know if or when apartheid would ever be over. And yet, here we are today where I can freely talk about the transformative constitution we have and how it can be utilized and mobilized to protect the environment and be responsive to climate change. And so as much as it seems devastating now in all of our different contexts, as Nelson Mandela said, it seems impossible until it's done. And so we should keep fighting because the world is on fire and not give up. Thank you.
Ladies and gentlemen, dear colleagues, thank you for this wonderful presentation. And now there is one more step we have to do. I kindly ask Professor Marcel Szabó, Justice Marcel Szabó of the Constitutional Court, to say some final words about the conference. My personal feeling is that after this two-day conference, that I assume the Hungarian Constitutional Court is now able to adopt at least two more climate decisions. And let me hear what Professor Szabó thinks.
They say that it is always the darkest before sunrise. And I think we have gotten to the point when we can see the first signs of sunrise. The world is in many respects in a terrible shape. The dangers are extremely big. The stakes are extremely high. But we can realize that there are in more and more spheres, there is more and more cooperation. And this conference was an excellent example for this. Take the example of public trust, how it is penetrating to every legal system by now. It was an absolute novelty in Hungary 5 years ago, and now it's self-evident as the Constitutional Court publicly referred to its judgment. And there are so many innovative solutions that are cross-fertilizing each other. And I know that the time is very short, but I can see more and more deep commitment that by the year 2050, climate neutrality has to be reached. There will be a lot of fight until then, but I really hope that this process is not going to be interrupted. I see more and more commitment in every aspect of the globe and in every aspect of different society that is really going to happen. And so that it happens, these conferences can really contribute, and the ideas can really matter and influence and have long-term impact and really contribute to big change in the world. So thank you very much for all and everyone, all the speakers, all the participants, and all those who are helping the conference. A big thank you for everybody. Thank you for being here. And I wanted to cut the end like yesterday, you know, taking the style of a Hungarian jerk, saying that it's time to go. It's not what I want to say. We have still time to stay. And I would like to recommend you to allow me a little touristic guiding at the Parliament as we are here. I'm recommending that we should have a look of the crown. We will not be able to speak there. So I have to say just one sentence. I don't want to speak away the time we have for looking around, but there will be two. We must leave the building at 4, so really there is a deadline of patience on behalf of the Parliament. But I would like to propose 2 stops in the building. One is just having a closer look to the crown. It's really at least 900 years old object, which was stolen several times. Last time it was removed from Hungary by the Hungarian Nazi and digged somewhere, and then the American army found and took it to Fort Knox and gave it back in 1976, and now it's here in the Parliament, a symbolic object of history and national unity. It has got 2 parts, a Greek crown and a Latin crown. Have a look, and let's gather outside, and after a few minutes we would go to the upper chamber, where I would be also speaking a little bit. Thank you. And just one sentence, those who have to rush, those who are going for the cruise, let's meet at 7 at the lobby. 7. Yeah. And let's do the crown and you would be a good group picture opportunity. Yes, very. Azt mondtam,